May I please, Your Lordship. In item number 25, my lord, in annexure, one page has been left out inadvertently. I want to incorporate that page, my lord.
Sorry, you want to correct?
I want to incorporate one page, my lord.
That's what
Annexure.
you want to correct them.
Yes.
I appear for the response.
Or I may be allowed to correct it before the registry.
You want to remove one page?
No, not remove.
Page, or you want to include one page?
Insert. Page number 18 has been left out.
Has notice been issued in this manner?
I
Yes.
appeared, madam.
Yes.
I am appearing for the respondent.
That should be subject to his approval.
So I have already taken consent.
Let the item. Let the item be called.
Okay.
Lordship, I beg from item number 33.
30.
Adjournment black.
Please give the listing, adjournment, everything. Please give. Item number for whom you appear, name of the council.
लिखित हो गया.
Item 1 for motion.
May I please, my lord? My lord, this is the intest case, my lord, probate case, my lord.
Robo.
Present respondent,
Why was it adjourned the other?
my lord, lordship was made some query, my lord. I could not satisfy your
Sorry.
lordship, my lord. Lordship was made some query, my lord. I could not reply properly, my lord.
Query.
My lord, what is the ground of this?
Robo.
Appeal.
No.
Yes, madam.
Query is who had made the will and who are the parties before it?
Yes, my
Who had made the will?
my lord, Anjali Mukherjee has made this will, my
Anjali
lord.
Mukherjee
Yes.
has made the will in favor of
In favor of the present,
them. So please say the name of the person. In
yes, my
favor
lord,
it was
Neelam Hazari.
in favor of Nilam Hazari.
Yes,
Who is property that?
my lord, property belongs to the Anjali Mukherjee. It initially belonged to her husband.
Today also will adjourn unless you give the answer. Unless you give the answer, I cannot understand your dispute.
My lord, I could not have.
Unless you make me understand your dispute, only then you can expect something from the court. So, Anjali Mukherjee made a will in favor of Nilam Hazarika. Why is Prakriti Das? Who is Prakriti Das?
My lord, Anjali Mukherjee expired issueless, my lord.
The petitioner to state before the court as to what is the relation of the appellant Prakriti Das with Anjali Mukherjee who had made the will.
My lord.
List again. Next item.
Lordship, 1 minute, Lordship. Lordship, 1 minute. My lord,
Mr. Counsel, if you don't cooperate to the simplest of
my
extent,
lord, 1 minute.
will is made by Anjali Mukherjee in favor of Nilam. We want to know why Prakriti is interested, and you are not giving that answer. Next item.
Neelam is nephew, my lord.
Next item. Come, give it to
Item
me.
2.
And that same question I asked you the other day also. Then only I can understand the claim of Prakriti, what kind of claim she has, unless,
Present all.
very well. Now, next item.
Lordship, this transfer petition was filed to transfer a title appeal from the Court of Honorable District Judge Pokrajhar to this Honorable Court. Because of
What kind of proceeding?
title appeal, Your Lordship.
Title appeal.
Yes, Your Lord. Actually, the appeal was filed at such point of time when
No, just we have 24 praying for transfer, withdrawal of title appeal before the.
this Honorable
You want to withdraw or transfer?
transfer, Your Lord. The CPC uses
No, you have written transfer stroke withdrawal.
the CPC uses the word withdrawal and transfer, Your Lord, because it is withdrawn from that court and taken up before. On the last occasion, Your Lordship, this Honorable Court directed me to approach this Honorable Court on the administrative side also, Your Lord. I have done that, and that
Just
is
a
allowed.
minute. Title appeal is pending before which court? District Judge
District Judge
Pokrajhar.
That number is
So title appeal 21, who filed the title appeal?
We filed the title.
You filed the title appeal.
It was filed at such point of time when Honorable District Judge had the jurisdiction. Thereafter, there was an amendment of the Assam, Agra and Bengal court. And the Honorable jurisdiction of the title appeal above 20 lakhs was to this court. First appellate jurisdiction was the Honorable High Court. And under such circumstances, when we
No,
approached
when you filed the appeal, who had the
the
jurisdiction?
Honorable District Judge,
And subsequent to
Subsequently-
filing, the jurisdiction of district judge had been
there was a bar on the District Judge of jurisdiction.
up to
and
20
Up
lakhs.
to 20.
And
This is
now the bar has been removed.
There is a bar
No, then where do you want to get it transferred?
to this Honorable,
To the High
to
Court.
the High.
Why?
Because now, after 20 lakhs, any appeal, Your Lordship, is filed before this Honorable Court,
What is the value of your appeal?
21 lakhs.
And at the time of filing, district judge had the jurisdiction. How do you lose if the district judge decides your appeal?
Lordship,
What kind of inconvenience you'll have?
because District Judge does not have pecuniary jurisdiction at this moment, Your Lordship.
Is it applicable to pending appeals?
Yes.
The hearing matter, register judicial.
Lordship, there was an exercise done in this regard. as
Was
well.
there any, is there any notification by the High Court?
Lordship,
And what is the language of that notification? Let us see.
This exercise was in fact done by the registry, Your Lordship. Lordship may find office note dated 27/9/23.
27/9.
On the basis of the previous order, I approached the registry as well.
Administratively, order has already been passed.
Yes, sir.
So we close this,
Only difficulty that I may face, Your Lordship.
I don't know. Once there is a judicial order to go to the administrative side, something has been done, we
Then
close it.
it is,
By the order, heard Mr. B.J. Mukherjee, the counsel for the petitioners. By the order dated 29/2023, while considering the present application under section 24 of the CPC, praying for transfer stroke withdrawal of the title appeal 10/20/21 pending before the court of the learned district judge Kokrajhar, it was provided that instead of entertaining the matter on the judicial side, it would be more appropriate if the petitioner would approach the High Court on the administrative side for appropriate orders. Accordingly, the matter was placed before the Honorable the Chief Justice and certain administrative orders had been passed. In view of the above, no further consideration required. Petition closed.
Item 3.
Yeah, please, Your Lordship. Lordship, my wife has filed a divorce petition before the learned court of the additional district and session judge of Jorhat, Your Lordship. So what has happened, Your Lordship,
You're for the
I'm
the wife or the
I'm
husband.
for a husband. So what has happened, Your Lordship? Recently, I have been diagnosed with thyroid gland cancer, Your Lordship.
So no, who had filed the divorce petition?
wife.
Wife had filed.
My wife.
In which place?
Jorhat, Your Lordship.
Jorhat. And where do you reside?
I reside in Barpeta, Your Lordship. So considering my illness, Your Lordship, it will be difficult on my part to travel from Barpeta to Jorhat, which is nearly 400 kilometers, Your Lordship. And apparently it's a matter of 2 days, Your Lordship. And even I've been advised by the doctor not to travel at this stage.
Take adjournment on medical ground. Hmm.
The title suit is faced before the mediation, Your Lordship. So at this stage, I cannot
Understand.
travel, Your Lordship.
No, transferring a suit on medical ground till now, this question had not been gone into by any court, if I remember
Yes.
correctly.
Yes.
If there is some decision somewhere, you are always welcome to produce it. Should you open up a new line for transfer of suits? Tomorrow, every husband will come with a medical document, say, this thing, transfer it to my place.
Ground is genuine, your lordship. Even I have annexed.
We
all
are
the-
not denying your ground that it is not genuine. It's a nature. The word cancer is a word of wide purport.
Yes, Lord.
You may be in the final stages where you can't even move,
Yes,
or
Lord.
maybe in the initial stages where you freely keep on doing everything. This is something to be gone
Yes,
into.
yes, Lordship is correct. Your lordship
But
is-
normally, most of the laws are in favor of the woman,
Yes, Lord.
that in a divorce matter, don't disturb them to come to another place to
Yes.
face a divorce. You being the husband, you go and attend it there. Normally, that's the principle,
I
unless
understand.
some,
If there is a chance of settlement, if we agree before this.
Settle
honorable
it.
court, so we can go for
well,
mediation.
you settle it, you are welcome to settle. You want to go to mediation,
Yes, Lordship.
go for mediation. Go to
Your lordship,
mediation
at
and
this
settle
stage,
it there.
Notice may be issued, your lordship.
Notice we will issue. Your name, please?
R Yasin, your lordship.
R.
R Yasin.
R.
R
Yasin.
Yasin. YSN.
Yasin.
Yasin.
Heard Mr. R. Yasin, learned counsel for the petitioner, issue notice, returnable 6 weeks, extra copies. No, steps on respondent, registered post 3 days.
Highly approved.
Let
Item-
the wife come see what she says. huh? All right. Your can কোনটোৰ matter মানে?
Pecuniary, ইয়াৰে আগৰ case, close কৰিলে।
নালাগে দিয়ক, চিফ জাষ্টিছৰ এপ্ৰুভেল এটা আছে pecuniary jurisdictionৰ ওপৰত।
হয়।
Transfer of suit on pecuniary jurisdiction. Is there any notification of the High Court? অকমান দিবচোন। সেইটোত পিছে দৰকাৰ নহ'ল, কাৰণ চিফ জাষ্টিছ has approved it. So we close the matter on that ground. But if there is any notification, এখন দিবচোন। মানে whether the all
দিয়া নাই, এনে
pending appeals are required to be transferred to the High Court.
Because of enlargement of the jurisdiction,
আপুনি mention
court
কৰি
of all of these apologies.
নহয়, এইটোতো উল্টা কৰিলে। Hey, that's what, hey, হেৰিটো চাওঁ, item number, এইটো যে close কৰি
Item 22,
চাওকচোন। Item 2 নহয়,
item 2, BJ Mukherjee.
BJ মুখাৰ্জীটো 2, 2। উল্টা। আমাকে মেজে টু অর্ডার দিলে, এটা again approach to administrative side. এই order to book করি।
Adjournment বিলাক কি? Item 4. Item 4.
None appears for the petitioner adjourned. Oh, you are there? Yes, please. What is the matter?
Okay, here we have 70 in order your lordship.
Mhm.
Find page 9 your lordship. Page 77 is the in order.
Notice is yet to be issued.
Yes.
Why?
Because the additional activities was directed to file by the commercial court.
Sorry, it was not directed. No. Order is L. Mohan submits, he requires 3 days time to file affidavit.
We accordingly file our.
So it is your requirement, not a direction of the court.
We file this additional affidavit bringing into record the objection filed by the opposite party in the violation petition. filed
This
by
is a revision against which order?
the lordship, page 77.
77.
Common order has been passed in all the cases filed by the.
77. Common order. What kind of? Mistake is 11540 arising out of what? LG 13 means?
13 land grabbing.
Huh?
Land grabbing. Action.
Land grabbing act. Land grabbing case. And Arman Ali is the plaintiff.
You are not petitioner, Arman Ali and others, two others are the petitioner.
Sorry, no, petitioner here is Rizwan Ali.
Here is the Rizwan Ali, he is the petitioner number 2 of the land grabbing.
Of the?
Original land grabbing.
Okay. So this petitioner is a plaintiff in the land grabbing case. So your land has been grabbed
And has been kept
by somebody,
by the opposite party.
that Mahfuzul Hussain and others.
That is the case, and honorable court, or learned court below has granted status quo order to maintain the status quo in respect of the property.
Status quo. What is the meaning of status quo? The grabbing should continue or the owner should continue?
No, there is no any change of the, page 35, we can see the status quo order. Yes,
No, no. After that, what happened? Who filed all these miscellaneous cases?
We,
For what purpose?
for violation, they have, because
Okay, once you got an status quo order,
they
they
have
had violated.
violated by constructing the building over the land.
So this is what I asked you the first question. What do you mean by status quo? The occupation of the grabber should continue or the occupation of the owner should continue? We send it back, ask the trial court to decide the proper injunction. Instead of going into this truncated status quo almost, yes, Mr. Mozumdar. Does status quo has any meaning in all these cases?
Context.
Land grabbing case. So what is the relevance of a status quo in a land grabbing case? The grabber should continue.
Whether here or not.
Don't disturb the grabber from today.
That is not the solution.
Therefore, all these confusions. Why can't the trial court decide the proper injunction?
Yeah.
And then
Then-
pass a specific order. Either the grabbers are prohibited from entering or the plaintiff is prohibited from entering.
This way or that.
And we see also no reason if somebody is the owner of a land, just because there is a civil dispute, no construction there.
Yeah.
So today I purchase a plot of land, you file a civil suit. It will continue for the next 40 years. That means I will not build my house.
Yeah.
That also can't be.
Actually, they have purchased the land of covered by another document, 423.
Huh.
And they have, after registration of this deed, they have obtained a certified copy manipulating the DAG number and inserted the DAG number of the present petitioners, 424.
So land grabbers have purchased some other land, and so and fraudulently they have included.
Included the land of the.
What
DAG.
is your claim? Did you take that stand that fraudulently they have included?
we have also lost this FIR to that effect. I have in additional affidavit, we have enclosed that here. This is the part of the record also.
But now in revision, what kind of order can I pass?
You know, this basically when the status quo order was passed, after violating that order, they have erased the consent.
This is what we are finding difficult. Who will determine what is the meaning of the status quo? Status quo means, as a child, did you play the game statue? Are we aware of it? Played it. Means moment one says statue, we have to remain there. As it is, you are standing. Status quo means almost that. So on the day the status quo was passed, who was in occupation of the land?
This is the opposite part.
So they will continue to remain occupied. So once they are occupying it, why should they not make construction over the land? So this is a wrong determination of an injunction by the trial court. But today, what order I passed? It's only a motion stage. Why were you satisfied with the order of status quo? We should have urged upon the court, don't pass this order. Either pass it this way or pass it the other way. And for injunction, the court can take the preliminary evidence also. Take the evidence, pass the order. Where is the order of status quo?
Page 33.
Hmm.
Page 33.
33. Who had passed it? Munsif, Margarita. Heard of the prayer of the petitioners for status quo. You must have prayed it. Where is your prayer?
Okay, page 17 is the petition.
No. Petition before the Munsif.
Page 17.
Page
17 is the original application. Page 17,
17.
Page 29 is the interim period. Page 29 is the operative period.
Page 29 is the prayer. So your prayer is to stop further construction and maintain status quo. Did you file any appeal against this order? You filed an appeal against this order. That my prayer was for stop construction and status quo, but the court did not consider the first part. We can be back. What does status quo means? Possibly status quo means status as regards the possession and occupation of the land. Status doesn't mean no activity over the land. No activity over the land has to be a positive direction after determination. What is your original piece? Where is the averment that they had fraudulently manipulated the sale deed by inserting some wrong DUG number? Where is that statement?
Page 26.
26. Which paragraph?
Para 16.
চকীখন ইমান ইফালে কোনে থৈছে? এক নম্বৰ এইডাল আছে, 2 নম্বৰ চব বস্তু ইফালে আছে, চকীখন চলিছে ইফালে, কেনেকে বহিব? এতিয়া মাতিলে দেখিবি এইটো চাব দিব। কেমেৰাটো আছে সিফালে, পোৱা ইয়াতে পেঞ্চিল সিফালে, মানুহটো গলো দেখি সিফালে লগতে আৰু এডাল এইটা ইমান চিধাকে বহিব পাৰি। Heard Mr. L. Mohan, Land Counsel for the petitioner. This is a revision under 115. The petitioner Rizwan Ali has applicants as applicant number 2 instituted land grabbing case number 13/2018 or 15,
15.
page number 17, 15, 2015, against the respondents herein, namely Muhammad Mafazul Hussain, Muhammad Sajad Hussain Ahmed, Muhammad Sadiq Hussain, as land grabbers, with the state respondents through the Deputy Commissioner Tinsukia and others as respondents. As per the application, comma, as per the application, land measuring 1 kotha 2 lesser of DAG number 424 of periodic pata number 13 and land measuring 4 lesser of DAG number 449 of periodic pata 12, together with some other land of the concerned pattas, were initially purchased jointly by Toibul Nessa alias Lutful Nessa, being the grandmother of the applicants and one of their brothers, alias Ilyas Ali, comma, Alibun Nessa and Afzalan Nessa. On the death of the joint purchasers, the shares of Taibun Nessa and Afzalan Nessa devolved by inheritance upon the applicants and their brother Ilyas Ali. Subsequently, Ilyas Ali died. In paragraph 16 of the application, it is stated as extracted. In paragraph 15 and 16, it is stated as extracted. From the reading of the four extracted paragraphs in the application, it's discernible that it is the allegation of the applicants that in respect of certain land purchased by the land grabbers, which is stated to be land other than the land of the applicants, comma, fraudulently the DUG numbers had been manipulated and the DUG numbers pertaining to the land of the applicants had been inserted. And taking advantage of such fraudulent manipulation of the sale deed, the land grabbers are presently illegally occupying the land of the applicants. I think that is your case. In the circumstance in the application in land grabbing case number 13, so and so, comma, amongst others, an interim prayer was made, which is as extracted. The interim prayer is twofold, that is to stop the land grabbers from further construction over the disputed land and to maintain status quo in respect of the land grabbed by the land grabbers as an interim direction under Section 8(2) of the Assam Land Grabbing Prohibition Act 2010. Land Grabbing Act on sound. কি করলো last sentence to? Full stop. The first prayer is on the basis of the assertion of the applicant petitioner, that upon indulging in land grabbing of their land, the land grabbers are indulging in certain construction over the land. And the second prayer accordingly would have to be understood to prevent the land grabbers from indulging in further construction over the land. As Section 18(8)(2) of the Assam Land Grabbing Prohibition Act 2010 had been invoked for the purpose of interim order, we also look into the provisions of Section 8(2) of the said Act of 2010, which is extracted as below. A reading of the powers under 8(2) makes it discernible that When the special tribunal take cognizance of and try any case arising out of any alleged act of land grabbing, comma, after the commencement of the act, comma, to pass such orders, including orders by way of interim directions as it deemed fit. In other words, the prayer for status quo under 8.2 would have to be understood to be an interim direction on an allegation of an alleged act of land grabbing. Based upon the interim prayer as extracted above, the learned Munsif Margherita in land grabbing case 13/2015 had passed the order dated 2011/2015, which is extracted as below. A reading of the order makes it discernible that the twofold interim prayer of the petitioner had not been taken into consideration in its proper earnest. That is, the first prayer to stop construction had not been taken into account, and the second prayer had been allowed that an order of status quo be maintained. The order of status quo again would have to be understood in the context of the provisions of Section 8.2 of the Act of 2010, wherein the statutory provision is to pass such orders, including orders by way of interim direction. An order of status quo ordinarily would be understood to be restraining the parties to maintain the status as it existed on the date when the order of status quo was passed. The applicants subsequently instituted which miss cases, all the miss cases.
Case 41 on
No, where is that order of the court?
page 77. Authority by page 78.
Had instituted Miss J cases 115/2015, Miss J case 42/2016, Miss J case 94/2016, Miss J case 04/2017, and Miss J case 10/2019. What do you do? Alleging that constructions are going on. Alleging that the respondent land grabbers are continuing with the construction over the land which was grabbed, and that such further construction was in violation of the order of status quo. The said miscellaneous cases were dealt with by the learned Munsif Margherita, Additional District Judge Margherita, by the order dated 28/3/2023. What did you find? What is the finding?
Finding is that they will also be find case 15 about it.
84.
Okay. Is the finding that any order has not been passed representing the power under order.
The learned additional district judge. The learned additional district judge proceeded to deal with the miscellaneous cases, aforesaid miscellaneous cases instituted by the applicants by referring to Order 39, Rule 2A of the CPC. Order 39, Rule 2A of the CPC চেঞ্জ কৰিব পাৰে। কিতাপখন কিয় গণ্ডগোল আছে নেকি? Order 39 rule 3 it was order 4 আহি গ'ল তাৰ আগৰ কেছত। বাইণ্ডিং গণ্ডগোল নেকি? কাৰণ 481 আগৰ পেজটো 160। বাইণ্ডিঙত গণ্ডগোল আছে নেকি? লাষ্ট সেন্টেন্সটো কি গম পোৱা নে? গ'ল। হ'ব নেকি? Order. Order 39 rule 2A is provides for the consequences of disobedience or breach of injunction, which provides that in case of disobedience of any injunction granted or other order made under Rule 1 or Rule 2 of Order 39, or breach of any of the terms on which the injunction was granted or order made, the court granting the injunction or making the order or any court to which the suit or proceeding is transferred may order the property of the person guilty of such disobedience or breach to be attached, or may also order such person to be detained in civil prison for a term not exceeding 3 months, unless in the meantime court directs his release. Admittedly, the consequences of a proceeding under Order 39 Rule 2A has its own consequences of the property of the person disobeying the court order of injunction to be attached or be sent to civil prison. And Order 39 Rule 2A pertains to a violation of an injunction that may have been granted under Order 39 Rule 1 or Order 39 Rule 2. In the instant case, it is distinctly noticeable that the aforementioned miscellaneous cases instituted by the petitioner is not an application under Order 39 Rule 2A, alleging the violation of any injunction granted under Order 39 Rule 1 or 2. The said application on fact and on its purport is an application alleging a violation of the order dated 2/1/2012, which apparently was passed under Section 8(2) of the Act of 2010, wherein there is a requirement of the court to examine requirement of the court to examine as to whether any positive direction is required to be passed on the allegation of land grabbing. The Act of 2010 apparently is a more stringent act to take care of the menace of land grabbing, where the preamble itself states that whereas there are organized attempts on the part of certain lawless persons operating individually and in groups to grab, either by force or by deceitful means or otherwise, lands belonging to the government, a public sector undertaking, a local authority, a religious or charitable institution or endowment, or any other private person. Firstly, it is noticed that the learned Munsif, while issuing the order dated 2/12/2015, had not exercised its jurisdiction in the required manner under Section 8(2) of the Act of 2010 by merely passing an order of status quo without taking note of the further prayer to stop construction and also the requirement of law to arrive at a prima facie satisfaction as to whether the allegation of land grabbing in the application filed by the applicant petitioners are factually sustainable or not. In the circumstance, it is noticed that jurisdiction vested under the law under Section 8(2) of the Act of 2010 had not been duly exercised by the learned Munsif while passing the order dated 8/2/2015, as well as by the learned additional district judge. While
Both are by the learned additional district judge, not by the municipal. Because it is the power under.
No, who passed the order dated 2/1/2015?
It is by the additional district.
But you said Munsif.
No, Lord.
ঠিক আছে, later on. কি কৈ আছো? Don't disturb now. কি কলো? Learned Munsif না লাগে, additional district judge, Margherita. Margherita. কলো। Under Section 8(2), as well as while passing the order dated episode order to the Kolu 2023 given in the miscellaneous cases number kita gote kita di diba sarita cases purportedly by referring to order 39 rule 2A. Full stop. The applicant having taken a clear stand in the application that the land under you have inherited the land of Mr. Mohan, you have inherited the land of Taibun Nesa and Afzalan Nesa, ne? Ki bolu? Land under Dag number 424 of periodic Patta 13 and Dag number 449 of periodic Patta number 12 out of a total land measuring 1 kotha 2 lesser and 4 lesser comma respectively. Ki bolu? Comma. Comma. A part thereof had been inherited by them under the law of inheritance, under the Muslim law, and with a further statement that the respondent land grabbers had purchased some other land not pertaining to the Dag number and Patta number applicable to the applicants, but had fraudulently manipulated the sale deed to include the Dag number and Patta number of the applicants is a clear and explicit case of allegation of land grabbing. by referring to the preamble of the Act of 2010, which provides that the Act itself is in respect of organized attempts on the part of certain lawless persons operating individually and in groups to grab either by force or by deceitful means or otherwise. Trying to occupy the land of another person by manipulating the dark number and pata number in the sale deed in respect of some other land would definitely be within the meaning of grabbing land by deceitful means. In view of such categorical statement in the applicant, it was the bounden duty of the learned additional district judge to make a preliminary inquiry on the correctness of the specific allegation made by the petitioners, if necessary, by taking preliminary evidence on the matter. From such point of view also, it appears that the jurisdiction vested under the law had not been duly exercised by the learned additional district judge while passing the two orders dated so and so, Agor 2 or Pisor 2. In view of the prima facie case being made out, comma, in exercise of the powers under Section 8(2) of the Act of 2010, the respondent land grabbers are directed and restricted not to undertake any further construction over the scheduled land in the application in land grabbing case 13/2015, and also be restrained from entering the premises of the aforesaid land. Full stop. Further, the order dated so and so, in this case so and so, shall remain state. Issue notice upon the respondent land grabbers, and upon their appearance, further continuation or discontinuation of the interim order would be given its consideration. All for the records of land grabbing case so and so from the court.
Okay.
6 feet.
Item 6 for admission.
No, in excess power under hearing, H2, direction 2, and under 115, stay and call for the records. Is it technically right? This order I dictated.
Yes, sir.
Is it technically wrong?
No, correct. Because the lottery.
I think revision court can exercise the power under 8(2).
Lottery is passed only in interim order.
But till then,
Other
Mr.
than-
Lay, you come forward. No, I think I can exercise power under 8(2). Revision court can.
Yes.
The original power can be exercised by revision court also, I think. Just check up the law. Possibly it is yes. No. Yes, Mr. Tiwari,
Hello, Reena.
that pension.
My lord. I'm
Mr.
ready.
Mukundar wants to begin, my lord.
And I've read it again. 143 makes it clear that in a family, even if there is a handicapped child, whatever may be his position, either he is youngest or may not be youngest, the family.
For the 143.
C, man. Lordship will kindly allow me to read 143, 1 and 2 up to Roman 1. That will make everything clear.
And Mr. Tiwari is agreeing with you.
Yes.
Then why should if you are in agreement, why should I hear?
My lord.
We pass an order on agreement.
Yes.
So now what should be done in this?
My only submission is that entry in the PPO, entry of the name in the PPO.
Make an application.
only that much.
Make an application.
But my lord, in application, if it is not done,
Have you filed your application?
My lord, they have filed an application, but then these things were not there on record earlier. For the first time, they have given, and the certificate given by the doctor or the board says that it's
So you file an application, they'll consider it.
yes.
What more can
because
we do?
Certain factual things I do not want to dispute. If
my lord, in the event of non-consideration, then the difficulty
Then you
would
come back.
arise.
Lord,
Again,
give
we have
me
the
liberty.
approach.
No, how can there be a preemptive writ petition?
Lord, it's not preemptive in the sense, since the
Mr.
name was, my lord, name was not in the PPO. We filed the application for entry of the name in the PPO. They are not considering the
No,
application.
he said it is inadequate. Find an adequate application, giving full particulars.
Very good.
Is stated by Mr. The petitioner institutes this petition under Article 226 of the Constitution of India, praying for insertion of the name of the disabled child of the petitioner in the PPO that is otherwise applicable to the petitioner. In this respect, Mr. P.K. Tiwari, Learned Senior Counsel, points out to the application dated so-and-so made by the petitioner and raises an allegation that the said application had not been given its due consideration. Mr. D. Mojumdar, Learned Additional Advocate General, appearing for the state respondent authorities, points out that the application does not contain the complete information to enable the authorities to pass any such order.
My lord, it is addressed to Commissioner and Secretary, Pension and Public Grievance
And to
Department.
whom it should be addressed.
That is all right.
That is correct.
Dated 12th
In view of such
2020.
statement, Mr. P.K. Tiwari, Learned Senior Counsel for the petitioner, states that the petitioner would file a substituted application containing the complete particulars.
details.
In the event any such application is filed, the authorities in the respondents may pass a reason order thereon.
My lord, within a specific period of.
The order may be passed within a period of 15 days from the date of any such application that may be filed.
Very
Petition closed with the above observation.
The date is 12/5/2020, date of application. Line pass.
deep there.
That's it. 12/5/2020. Item 9.
But it still appears to me it's a separate one.
My lord, I
I'm
also
not
repeat
going-
number of times, my lord, somehow.
No,
anyway, Later on, we'll discuss this.
No, it
Of
still
the-
appears because only the name family pension is common. Between 143 and 143, only the name family pension is common.
Lifetime is.
And
second.
name does not indicate, suppose there is another person named Pawan Tiwari, it will not be the same person. That Pawan Tiwari will be different and this Pawan Tiwari will be another person.
That's.
You are going only by that expression, family pension. Otherwise, the purpose and purport of both the rules are totally different and unconnected with each other.
My lord, I thought over this.
And
conceptually,
moment it is, yes, I'm telling you one more thing. This disabled child, the day he becomes a major, he is no longer dependent on the parents and he has an independent legal right of his own to get the family pension on his own entitlement,
my lord,
not linked up with the
my
parents.
lord, I did look into this aspect. I thought of this.
Yet
my
you
lord,
may have
but-
thought, but you had not,
Dot.
you had not thought the complete thing.
My lord,
Because now this disabled child is subjected to receiving family pension to what the mother is getting, as long as the mother is alive. But if you read it carefully, all the words,
my lord,
if you read carefully, this man has an independent legal right the day he becomes 18-year-old.
my lord, I'll put it this way. Once his name comes in PPO and mother passes away, he will
No.
continue to get the. family
That's
pension
where you
so
were
long as
wrong.
he's alive.
He is entitled to a separate PPO of his own.
My lord,
The concept of that full bench judgment, one PPO, is applicable for a pension under 143.
my lord, but that PPO would come into play.
You-
That
what-
PPO would-
Mr. Tiwari, why you're so
Concept-
hardened up with the concept PPO? PPO is a document which pension is paid, nothing more than that.
But my lord, so long as
And-
the mother survives, so long as the mother is
Mother
alive,
will keep getting her pension.
that there, my lord, I was having a problem. I
Because
thought of this
we
again
are,
and again.
we are thinking it for the benefit of some disabled people,
that
in the
is
public
true.
benefit.
But
Not if your,
my lord, result would have been the writ appeal thereafter, and my lord, matter would have continued for a very long time.
Let
And,
the authority take the.
So, my lord, I thought over this again and again. and
you
somehow-
were on to avoid writ appeal, you were passing this, taking this stand, we understand.
I
even-
found it difficult to reconcile.
Even writ appeal, we thought about it and there was a way out of it also.
My lord,
to protect you.
I found it difficult to
Don't worry.
reconcile with the concept, honestly. We'll discuss.
Two are totally different concepts, unrelated.
I did think about it, but conceptually, my lord, still I say, my lord, I had my difficulty. You know,
Then let's begin the hearing then, start. Start. Yes, start, argue.
let it be some other time, some other
Argue.
case,
No,
not
you-
today, Let it be some other
So
case.
we are
No, no,
little,
I
we are
can
little
see.
concerned on the entitlements of some disabled people. Because disability law is a special law all along. Disabled persons are entitled to many things which many other people are not entitled.
And even,
This
my
is-
lord, after the representation,
Hmm.
after the application, my lord, let us see, my lord, if the situation arises. We
It
go
will
on
not
that.
arise, they will add to you and end of the matter.
My lord, but in any case, because he can't look after himself. So after the mother, he will get the pension and then we will see, my lord.
No, money is not only looking after, money is for many other purpose. This disabled people have own special expenses to meet to overcome their disability. Apart from getting the 2 square meals to be provided by the mother from the pension. The minor is given 2 square meals by the mother from the pension and also other expenses, because that is, the minor has no other entitlement of any other pension other than the 143 pension. Okay. 143 pension is applicable, the horse 143. You don't even have to look at 143. It's an own independent provision and entitlement under the law, considering the special needs of a disabled person.
But there also, my lord, it is written, if there are minor children, the minor children will get it first and then it will pass on to the disabled. There is a clause over there also.
We'll give an interpretation to that. Don't worry, it's not there. Where is that clause? Because I read this matter with Mr. Muzumdar once, I remember.
Where is my book? Where is my book? My book is being carried by.
If somebody is entitled to Mr. Muzumdar, somebody is entitled to give it. Why are you so stingy with her? And how many complete disabled child will be there of government employee? Hardly 100.
No, I'm on.
How much money you were paying? And see the social benefit of that provision. How much pension you are paying? About 10,000? Nothing beyond that. If there are 100 child, you'll be paying 10 lakhs rupees. If there is a general benefit to the disabled people, I think then ours is a welfare state. For that much of welfare, I think you can afford it. It will not be that there will be millions of such people. A few handful will be there. Which provision you are reading?
My lord, in fact, should I? Because, my lord, I started with 143C, section 1. This rule shall apply, application of the rule, the categories. This rule shall apply to pay lifetime family pension to the handicapped son, daughters of government servants who retired, died while in service, both. So sons and daughters. Subsection 2, if the son or daughter of a government servant is suffering from any disorder or disability of mind, or is physically crippled or disabled, so as to render him or her unable to earn a living, even after attaining the age of 18 years in the case of the son and 21 years in the case of the daughter, the family pension shall be payable to such son or daughter for life, subject to the following conditions. So
Yes.
the conditions are: one,
Mm.
if such son or daughter is one among two or more children of the government servant, the family pension shall be payable to the minor son or daughter, as the case may be, in the order of their birth.
So if the son or daughter, if such son, the disabled, is one among two or more children of the government servant, the family pension shall be payable to the minor son or daughter, as the case may be, in the order of their birth,
Yes.
until the last minor son attains. So how does it help
Last
you?
minor daughter attains the age of 21 years.
Minor.
The whole
See,
pension is meant for the sons and daughters as a
Mr.
whole.
Tiwari, entire 43C is not related to minor. It is related to person who has attained the age of 18.
Yes. Thereafter, it passes on to
So-
the disabled and
So
continues.
these are only explanatory to what will happen to the 143 pension, which otherwise is paid to the family. This one carves out an exception that what entitlement of 143 to those minors, remaining minors, they will not be affected by this one.
Yes. Thereafter,
But-
it will pass on to disabled.
No, this is in favor of the disabled child.
Yes. Yes.
If the disabled is paid, whatever is paid to the otherwise to the minor, if there are more than, if he is among two or more, suppose other than he had attained majority,
Yes.
to come in under 143.3, the disabled child has attained majority. One independent right under one,
Yes.
unconnected with 143. But once this boy is paid, this
Yes.
child is paid, what will happen to the 143 pension that the other minors are entitled? This is the explanation given in these conditions. These conditions do not in any manner restrict the entitlement under 143C1 of the disabled child. Please read it carefully.
My lord, I'll concede,
Mm.
my lord, let this explanation be accepted. And
No,
lordship may
but
pass
as the
accordingly.
matter has come to a notice, we want to take it up. Why should he deprive a number of disabled childs
Very
from
well.
their entitlement?
Very well. I concede, yes. This explanation may be accepted.
I make one.
Mhm.
I've got one second.
And you are relying on another one. Which
No,
provision?
no, I'm relying on this. Lordship will kindly permit to read the entire paragraph.
Ah, you
then I
read
make
it.
my submission. If such
Until,
son
huh,
or daughter is one among two or more children of the government servant,
huh,
if family pension, Lordship will kindly
Ah.
note, family pension
huh.
shall be payable to the minor son, not to the handicapped. Lordship will kindly permit me to complete. I'll make my submission. Lordship, just 1 minute.
Okay, but the answer is ready.
My lord,
Whatever you
My
are
lord.
trying to say.
The family pension shall be payable to the minor son or daughter as the case may be in order of their birth until the last minor son, not the handicapped son, last minor son attains the age of 18 years or the last minor daughter attains the age of 20 years as the case may be. And thereafter the family pension shall be resumed in favor of the son or daughter suffering from disorder or disability of mind or who is physically crippled or disabled and shall be payable. The meaning is, my lord, if there are three, I'm giving an example. If there are three children, one of them is crippled, handicapped. Now he will not get anything. Family pension will continue till the last minor son. He may be crippled, he may not be crippled, a normal one. Last minor son becomes major. Till then, the family pension will continue. After that, normally, family pension will stop. But if there is a handicapped son or daughter, it will resume thereafter. Then thereafter, he will get it.
Anything more?
Till his life.
Do you want the answer?
Yes. And the second part, Lordship will kindly see the second paragraph of the
Okay.
If there are more than one such children suffering from disorder or disability of mind, or who are physically crippled or disabled, the family pension shall be paid in the order of their birth and the younger of them will get the family pension only after the elder next above him ceases to be eligible. That means if there are two, the elder one will get, younger will not get. Thereafter it says, provided that where the family pension is payable to twin children, it shall be paid to such children in equal share. So even then, one family pension. So well, the first paragraph which I was reading says that if there are 2, 3, 4, whatever number of children, and one of them is handicapped.
এই আগৰ অৰ্ডাৰটো interim কৰি থৈ দিয়ক, we'll continue with this hearing. And for the other part, we appoint you as an amicus, Mr. Tiwari. We continue with it. This one, let it be an interim order, you get your benefit.
Very well, very well,
So there is no question of any appeal also.
Yes, yes,
Don't
sir.
worry.
very well.
Then doctor may take it up some other time.
No, we'll let us set the questions to you so that you can come prepared. Otherwise, you'll always be
Yes.
taken a little surprised by the
Then you
question that we may ask.
A couple of minutes, I'm just trying to, possibly I'm not been able to convey what I'm actually. These provisions state.
Mr. Mojumdar, we are feeling possibly we are not able to convey you what we are asking you.
I'm thinking about my disability.
See. Read 143 from the beginning once again.
Yes, 143.
See,
See.
forget about 143. You are not concerned with that one.
Yes,
Unless it is interlinked with 143C. 143 will continue on its own. This rule shall apply to lifetime family pension.
Yes.
This concept itself is a concept other than family pension.
Yes.
Family pension means for the spouse,
and minor.
it is lifetime. For the minor children, till they attain majority, daughters, whatever is provided for. That is one kind of a family pension, which is exclusively provided under 143(3), and you need no further provision for that purpose. 143 does not provide anything for a disabled child.
Yes.
After attaining majority.
Yes.
Before attaining majority, he is covered by 143.
Yes.
By virtue of being a minor child, but not by virtue of being a disabled child. Okay. Now, this is we have to consider to be a socially beneficial legislation. And the interpretation to be given is a beneficial interpretation,
Always.
that the maximum of the benefit is provided. Restrictive interpretation is not
No.
permissible in this kind of provisions. This is one. 143C1 is a independent provision on its own without any condition. Okay. Two further 45s that the day the son becomes 18 and he is disabled, the daughter becomes 21 and she is disabled, you are entitled to the pension under lifetime. Two conditions. Firstly, you have to attain 18 and 21.
Yeah.
Second, you must be disabled.
Yeah.
Medical documents should be there. Two conditions. 43C is applicable. 2 is not an independent provision. 2 only, 45 is 1. While 45 1, you also bring in subject to following condition.
Yeah.
And you are now relying on condition. And see the status of this condition. Firstly, it's a condition attached to a fortifying provision, not even to the main provision. Had it been a condition to the main provision, it would have been included in 43(1), subject to. It is not done so. 43(1) is an independent provision, unconnected with anything, any other provision. It's a benefit. Now read conditions. If such son or daughter is
One
among the two children,
Yeah.
such son, daughter means the disabled.
No, this son or daughter is not disabled man.
such son or daughter.
Yeah, yes, yes, here it is.
It is here, it is
Yes, yes.
disabled,
I'm sorry.
nothing else.
Yes, yes. This is-
That means the such son or daughter who had attained the majority
Yeah.
and entitled to family pension is among two or more.
All of whom are not.
Uh-huh.
uh,
So
uh,
all of them are not, is among two or more.
Yeah.
The family pension.
Yeah.
This family pension refers to
That family pension.
143 family pension, not
Exactly.
this 143C.
No, minor, yes.
Shall be payable to the minor son and daughter. Means the,
Any minor son.
no,
Yes.
among the remaining of the two, such person is already a major. He is not a minor. When this condition is to be read, the factual situation is the such person is already a major. He is not referred as minor anywhere. This minor means among two or more, the other. When, if among the two or the other, he is a minor son or daughter, as the case may be, in the order of their birth until the last minor son attains 18 or last one is.
Yeah.
They will be continued to pay.
Yeah.
This,
Till they
this
pay.
one says, now if 143C's special lifetime pension is paid to the disabled, this will not truncate the right of the other minors to get the 143 pension till they attain the age of 18 or 21, and then read, as the case may be. And thereafter what will happen? The family pension shall be resumed. Moment there, just a minute. Moment there is a word resume, there has to be a,
Existence of.
no, agrees, there has to be a breaking up somewhere.
Yes, break.
Today I am sitting now.
Yeah.
After I get up for 5 minutes and come back, I resume the court. Why? Because now I am
There was a
sitting.
break.
Suppose I would not have been sitting in the first half and come back only at 12 o'clock. I'll be sitting in the court at 12. I'll not be resuming it. So resume always precedes a stoppage.
Yeah.
Understood? So there is no provision prior to this provision that the disabled major child, he'll be given a pension, then it will be stopped somewhere. He'll be given and stopped. To resume, it has to be stopped. So this resume means shall be resumed in favor, means once the other two minors, it is 143 is stopped to them, that will not be a reason to stop the
Family pension.
family, this special family pension to the disabled, merely because the others have attained majority.
No, the resumption is of family pension, not family, like not lifetime family pension.
No,
not family
no.
pension.
Then
This
this says this is redundant, has no meaning. Number one. Number two, 143 is a special law. It's an independent law. It will prevail. Secondly, you may go to the law of exceptions, because 143 is a specific provision. Day you attain majority, you'll get a family pension. Now, if you read these conditions, to truncate it, it's an exception. Read the interpretation, how an exception is to be interpreted, you'll get the answer. The one you are reading is to convert the exception to be the main provision. You cannot do that. You will continue with the hearing. Please read it from this point of view. And thereafter resume. You are relying only on the word resume. And resume resume word can be interpreted in one line.
Yeah.
Moment there is no stoppage, there is no resume.
Yes.
And resume
Because,
means,
my lord,
and the word resume will have to be understood to be, will be continued.
yeah.
Continued means,
family pension.
no family pension. 143 lifetime special family pension. Family pension stops.
Before we conclude,
Understand, family pension stops. Otherwise, 143 would not have been an independent provision. It would have been a further proviso under 143 that in the event the deceased government employee leaves behind one disabled child, in spite of the entitlement being only up to the age of majority, the disabled child will continue for his lifetime.
we'll revert.
Otherwise, 143 cannot be given any meaning. Yes. When do you want? It will interim list on so and so forth again.
The order remains so far as this case is
Yes.
concerned, right?
Let it remain.
That is that.
Let them take the point.
Now, Mr. Tiwari may start thinking otherwise also. My purpose is served. Let me look it the other way around now. Yes.
In a different way.
It will interim
Hello. In larger interest, my lord, we can go into the semantics and the
Please
interpretation
look
of
at it
law.
properly.
But because if the lady dies,
These
then
are
we have a problem.
only explanations. What will happen to those other minors once you get this family pension, whether they will continue to get or not, they will continue to get until they attain majority.
Yes, yes.
And when their pension will stop after getting majority, this will be continued. The word resumed has no meaning on its own, minus there is a prior stoppage.
Another issue will be
And the word resumed would have to be read to be continued.
and
Means this will not truncate
another
it.
issue without would arise, expression minor used in 143C, whether the expression minor used in 143C is the minor in 143 simpliciter. And the significance of that.
143,
Later on be-
143 is also 18, 43C is also 18.
Yes.
Doesn't make any difference.
Very well.
Yes, next item. Mr. Mojumdar, be a little more benevolent.
No,
Give-
I'm
give it,
not on the amount, etc. and the entitlement of that. I'm only on the.
No,
the
it's an,
lottery
this is an entitlement actually, independent entitlement. And
Right.
this is again subject to, because this disabled child will have to look after his own disability. Once he is a major, he is dissociated from the mother. Mother out of motherly care may continue to look after him, take care is a different matter. But law understands he is now on his own.
He take care.
He is on his own. Now he'll have to maintain himself. Secondly, he'll have to maintain his disability also.
Right.
So law gives him some money. You do it on your, manage on your own. We are not questioning the motherly love of a woman, but we are examining it legally. Legally, that mother is no longer required to look after this one.
After
Hmm.
become.
Even the motherly care may not come. So he'll have to
Take care of it
hire the motherly care that he needs.
financially.
So the law provides him for something.
Let us have it in the first week of December, first week.
No, next week.
Next week I have some, there, week there. I'll
He
not
will be in
here.
Delhi, he will be in Delhi.
The week there.
Have fixed date at the video. See, think it from the, it's a beneficial legislation, how to interpret a beneficial legislation.
I'm not.
And secondly, even if you read the conditions of 143C2 to be exception to 143(1), how that exception is to be read.
Let us speak.
And only one word, resume, will not change the whole context.
All right.
From the honorable court, I'll go for the purpose of family pension only for my mother. I'll go to State Bank from here, straight away. So I was also
Mother.
worried. November is the month.
go to family pension via Mr. Mojumdar's client. You will have to make the application.
He will pay for the central government, my
My
lord.
lord, in my case, central government.
Central government.
In my case, central
Central
government.
government.
Which case?
In his personal case, from
Oh.
the central government.
Okay,
his
personal,
mother.
personal.
Because my mother is getting family pension, so I said, from the court, straight away I'll go to State Bank for fulfilling the formality of getting the family pension in the month of November.
For you,
Yes, my lord.
personally.
That's my mother. My mother is very much alive,
Huh?
so my mother gets the family pension.
Huh,
So
she'll-
once in a year, in the month of November, we have to fill up a certificate,
I know
life
that.
certificate. So for that purpose, I will have to go.
No, that I know.
So, I have to go to State Bank from
One,
here.
one of my aunts, she was very old. The son who was doing it, he died.
Uh,
So I used to do it for her.
so, my lord, in this case, I do it.
You have to go to the State Bank,
29.
put some signatures in some paper, they'll ask you a few questions and it
Yes,
is continued.
that's it. That's it. My case, they know me, but.
And
they
you have to
need see.
also bring some document that the pensioner is still alive.
Yes, yes, that's
Yes,
it.
that is the part.
That is the purpose. So, my lord, 29th, I believe, 29th of
All right.
November.
No,
You'll be leaving.
No, no, he will be leaving, not I.
no.
I'm very much here. From the court, I'll go to bank right now.
No, 29th you are
29th.
leaving to Delhi.
29.
Well,
Next week,
today is
17.
7.
12 more days in between.
Yes, that's why he will be here.
So 29th, I'll be able to attend, my lord. No big deal.
For 29 you'll be coming back or going.
29th, he will be present, my lord.
Oh, present.
Before my lord.
Okay,
There is no difficulty.
okay. 29.
Please, your lordship. Lordship, this appeal has filed for modified the judgment, lordship. The judgment has passed by the Railway Claims Tribunal, lordship. Appeal
What
will
did
be-
you admit the appeal? Admit?
Lordship, I have annexed one order copy, lordship. That modified has judgment has already modified without LCR, lordship.
Who modified?
What happened, lordship? I appeared on that case, lordship. Lordship, in page number 25, lordship.
In this case, somebody modified or in some other case?
Lordship, it's other case,
Similar
lordship.
case, lordship.
Similar case, lordship.
Similar ground.
So
Yes, it will
we may
also
not
file-
follow that without hearing it. Page number
25, your lordship. That's the order.
25 or 26?
Short order, lordship.
This is against railway claims.
Railway Claims Tribunal, lordship.
For whom do you appear?
Lordship, railway, lord.
Railways. And yourself?
Yes, I'm in item number 9.
And
Item number 10, lord. What are similar matter?
okay, both are jointly stood up for 2 items.
Lordship, just modify, lordship.
So you're not objecting. You're also not objecting.
Lordship, modification is regarding the
That fixed deposit.
lordship, fixed deposit.
You don't want the
And
money in the
this-
fixed deposit.
This order is passed as per the notification, lordship, it is mentioned in the order itself. There is a railway notification dated.
That something should be put in the fixed deposit. Then
Therefore, it may be taken up for hearing, lordship, may be admitted.
Lordship, our awarded amount is 8 lakhs, lordship. Only 2 lakhs can be released, lordship. So,
Remaining,
lordship.
no, this is a, Madam Kolita, this is a beneficial provision
Yes, lordship.
to protect the claimants. These claimants are normally, they're economically little not well off. So if they are paid the entire amount, within a very short time, the whole amount will go. What they will do after that? So the authorities think that let us pay cash amount of some extent, and the balance will put in a fixed deposit. And fixed deposit for 3 years.
Yes, Lordship.
You'll get interest. And after 3 years, the money will come to you, so that you can enjoy the money for a longer time.
She is now 60 years old, Lordship.
So
This is a mother of the deceased person. This appellant is 60 years. She is
why does she want the money? What will she do with it?
Lordship, medical ground, Lordship.
No,
Yes,
not
no.
casually. You file an affidavit, why you need the money?
Okay, Lordship.
And for specifically for what purpose you will use it.
Okay, Lordship, I have.
And we'll also ensure that you don't use it for any other purpose.
Okay.
What happened in Lordship, Gita Devi case, Lordship, that was in Patna and Lordship, there were some lots of document, there were some bogus claimants reported. Regarding, that's why Lordship, and what happened in Lordship,
No, we don't go to this. We don't, without any appeal being filed, we cannot take note that Madam Colita's client is a bogus claimant. We'll definitely not go into that question. And if you feel so, file an appeal, we'll test her whether a genuine claimant or not. But otherwise, it's a beneficial provision. Why should we interfere in an appeal?
She is only dependent, Lordship. And now she is 60 years old.
What is the amount given? 8 lakhs.
8 lakhs.
To how many people?
She only one dependent.
She is the only one.
Yes.
And you need the whole money.
Lordship, no, whole money not required, Lordship. Only 4 lakhs may be released, Lordship. 4 lakhs may be released on 4, 5 years, 6 years. I have no objection, Lordship. Only 4 lakhs.
Now how much is released? 2 lakhs.
2 lakhs, Lordship.
You want 4 lakhs.
Yes, Lordship. I have no objection if 4 lakhs may be fixed for 6 years. I have no objection, Lordship. But now money is required for medical grounds. She has no house, Lordship. She now help.
File an affidavit.
Okay, Lordship.
The appellant to file an affidavit as to why a further amount of rupees 2 lakhs is required to be released in favor of the appellant. And for what purpose the money is required and would be used. If it's a good cause, we'll release it. But otherwise, it is for your safety, so that because your son would have looked, suppose you live for 90 years now. Your son would have looked after you for 90 years. Now you have only this money to take care of you for the next 30 years. If you spend the entire amount in this manner, you'll be in the streets after a few days. No son to take care. This money also over. So the authorities feel that.
Lordship, 4 lakhs may be fixed. 4 lakhs.
I know it is your statement. So we want to know for what purpose this money will be used. Money may be used for any unnecessary purpose also.
No, Lordship, he is now beggar, Lordship. So, Lordship.
File affidavit.
And another item, Lordship, item number 10.
There are 6 dependents.
Here is 6 dependent.
And so now what happened here? Here also same. Some amount in fixed deposit, some amount paid.
Yes, Lordship.
You want the more money.
Lordship, there is mother and father, Lordship. Mother has Lordship, appellant number 5 is father of the deceased person, Lordship. And appellant number 6
Is the money required to repay some recent debt?
only 50,000.
Madam
Can
Colita, is the money required to pay some very recently acquired debt? Is it so? This lady very recently must have owed some money to someone,
Yeah.
and they need this money to repay that debt. Is it something of that nature? Are you sure?
Yes, Lordship. Lordship, there is mother and father of the dependent, Lordship. 50,000 can release, Lordship. 50,000.
What is the total amount paid?
8 lakhs, Lordship.
8 lakhs. How much is released?
Lordship, appellant number 5 5 shall be payable to the father of the deceased person. 25,000 can release, Lordship. 25,000 may be fixed, shall fix, Lordship.
How much amount? 8 lakhs has been paid.
Yes, Lordship.
And
There
how
is-
much amount has been released? 2 lakhs.
Yes, Lordship. Lordship, appellant number 1 has, the awarded amount has divided into 6 parts, Lordship. 1 lakh to the wife of the deceased person, and appellant number 2, 3, and 4 are their minor children, Lordship. I have no objection that amount has fixed, Lordship. And appellant number 5 and 6 is the are the mother and father, Lordship. They can they have Railway Claims Tribunal has paid 50,000, but 25,000 can be released. 25,000 shall be fixed. Only 25,000.
It's a very difficult question to answer.
For the protection of the.
Definitely, it's for your, these are welfare measures. It is nothing illegal. But you, again, file your application, what will you do with the money? We want an affidavit.
Yes.
For what purpose money will be used?
Okay. I
To
have
take care that the money is not used for some unnecessary purpose. And if the money is for repayment of some recently acquired debt, then we'll not allow it. Yes, next item. List next week.
Item 11.
Appeal file under section 82 of this is an appeal file under section 82 of the ESIC Act. Yes, ESI Act. Yes, no. And against the order passed by the learned EI Court dated 31/7/2003. Yes. My lord.
Elsmith, counsel appellant, admit, return about 6 weeks, steps on the respondent, register post 3 days.
No, the LCR may be also.
Call for the LCR of case number 6.
Hearing under order 41, item 12.
Yes, sir.
This appeal is by the plaintiff, Lordship. Suit for right title insurance and recovery of possession.
Where is the substantial question of law?
Page 4.
Page number
4.
4.
Plaintiff exhibit 1, Lordship, to sell it in original, Lordship. That was
Madam Chaudhary, we ask the same question every day. How second appeals can be based on some 8 or 9 substantial questions of law?
only one, Lordship, if Lordship.
See, if you read the Supreme Court judgments, what is a substantial question of law? With great difficulty, you can frame one substantial question of law. In many cases, possibly you cannot even frame any substantial question of law. Now, how can, in this situation, we have 9 substantial questions of law?
In this case, what happened, Lordship, exhibit.
Reframe it properly. Whether the finding arrived by the dismissing without, this is a vague ground. with the learned court correct in discarding prayer of the appellant under order 41 rule on the ground that evidence at the appellate stage would be like allowing them to plug the loophole.
My order 41 rule 27 petition was not
Mm.
considered by the first appellate court. As per Union of India and Ibrahim Ali Lordship 2008 SCC Lordship. Is to be considered at the time of hearing.
Order 41. Mr. Mohanto, why CPC is always in this Roman numbers? X, V, L, Y, I, whatnot. Hmm.
Probably.
So difficult to
Very
read.
difficult, man.
41 would have been
41
very
very difficult,
easily to read. Straight away you can come there.
XL1,
But XL1.
very difficult.
Hmm.
Probably
See,
origin from Roman that
The Indian numerical system
1 to 3.
is understood to be the best in the world, not now, historically also. Discarding our better system, why do we adopt some foreign thing which makes it more
I
complicated?
have seen, madam.
Hmm.
I-
Always, all books are this X, L, Y and
Yes,
everything.
madam. It's very difficult to find out.
Suppose you write in numerical, order 41, 41,
XL1.
rule 27, 27. No, you don't lose anything
Yes.
or your status comes down.
Definitely not. Probably originating from Roman, that's why it is still going on.
You have to keep on digging the book.
Difficult to
Where,
find it out.
where is that XLI one is there? Because after 39,
It will be
39 it will be 40. After 40 it will be 41. Moment you are in 39, you can skip a few pages and see whether it is 41 or not.
39 all.
But once it is all X and L and V and everything, you need another few seconds to discern what exactly it means, then find out where is the. Is it, are you associated with the law commission somewhere?
I'm not.
Why can't you
Yes, it
take a decision to convert it to a more simpler method?
simplified way. It will be more simplified way, madam.
That's what.
I always, madam, after 40.
So difficult to find out the actual one.
After 40, it is.
XLI 27. Huh?
Yes.
XLI. Because Romans never had the numerical system. They had only the alphabetical system. So the alphabets were converted to a numerical system. So they are an inferior system. And ours is a superior system.
Both numerical
And you discard the superior and go for the inferior and create all the confusions. And what is the Supreme Court judgment you say?
But this is Union of India versus Ibrahim Hussain. This says Lordship
Page the paragraph number.
that
Which para you want to rely?
para 41 maybe.
Is the and where is your application? What is the ground in your application under 41 rule 27 application?
Lordship, I have found that
So why do you want to adduce additional evidence?
Lordship is the scribe of the sale deed, Lordship, the registered sale deed which
No,
I can
no.
produce.
I'm not asking that why. Was this evidence refused by the trial court? It
Yes.
was refused.
Yes, but not proved. It was
No, no.
held by the trial.
This additional evidence that you want to bring in now, was this evidence offered but the trial court had refused to admit it?
court. Lordship refused by the first appellate court.
Come to 41 rule 27. Production of additional, the parties to an appeal shall not be entitled to produce additional evidence, whether oral or documented, if the appellate court, in the appellate court. It's a general bar, you are not entitled. But if, one exception, the court from whose decree the appeal is preferred, that means the trial court, has refused to admit evidence which ought to have been admitted. Do you satisfy this requirement? Was this evidence tendered but the trial court refused?
No, Lordship.
No. Then what is your ground? Second reason is, party seeking to produce addition establishes that notwithstanding exercise of due diligence, such evidence was not within his knowledge or could not, after exercise diligence, produced by him. Do you satisfy this one?
That is not within my knowledge whether they summoned these witnesses during the trial. For that, Lordship, I have to go through the entire court.
No, you have to.
Lordship.
We can
Then-
we can frame a substantial question that this ought to have been done, not done, so we'll stay the judgment.
Then.
But unless we get material to frame the question,
Then on next week, Lordship,
Hmm.
to Wednesday.
and third is, the appellate court requires documents. So this is the discretion of the court.
Right.
Requires any document to be produced to enable it to pronounce judgment. This has nothing to do with the litigants. The court, while intending to pronounce a judgment, finds that we need some more evidence. Then court can exercise this power. Therefore, Supreme Court has said that this should be done at the stage of,
Hearing.
at the time of hearing of the appeal on merit.
Lordship.
So when the lawyers are arguing on merit, if the court feels, oh yes, to decide this, I need some more evidence, court will invoke this power. Or the lawyers themselves may argue that for a proper pronouncement, this material is required.
Then on next date, Lordship. I
So
will
now
go
you
through the entire
please
trial
look into
process.
your petition, find out what kind of case you have made out, whether you are covered by Rule 27A, double A or B. Once you that, we'll frame that question then. Any other question? Judgment and decree passed by the dismissal without considering provisions of law regard to proof. This is a vague one. Just a minute.
In respect to the
Without
proof of sale.
considering the provisions of law in respect to proof of sale deed is where. In which manner it was discarded?
Lordship, we have produced the original.
Registered
sale
sale deed, I understand.
Original.
As exhibit,
Exhibit 2, Lordship.
exhibit 2.
Yes.
I
There was no objection,
understand. Why was it rejected?
Lordship, that we have not called the
The,
vendor.
please show that provision.
That-
Show that provision in the order where it was rejected.
That is,
Why the registered sale deed was rejected by the trial court and the appellate court?
Lordship. Para 30, page 30, Lordship.
One
By
three.
the trial court.
1-3.
30, Lordship.
3-0. No. The PW produced original sale deed to manual nothing. It's a registered cell deed,
Yes,
original.
registered original cell deed, but
Hmm.
it mentioned in para 30 itself that the PW one has produced the original sale deed number so and so as exhibit 2.
So SP Roy is looking. Yes, Mr. Roy. I think recently you got a judgment in your favor on this issue. Hmm. Where is that Supreme Court judgment? You referred one. Ase niki thoa? Hmm. You remember the citation of the Supreme Court judgment you relied on? Heard MS R.A. Chaudhary, Land Council. Prem Singh, yes, Prem Singh. আমার ইয়াত থোৱা আছে নেকি? নাই। Get it? ক'ৰবাত। আজি নালাগে, এনে পিছত। You are the plaintiff?
Yes.
Heard the MS R.A. Chaudhary, Land Council for the appellant? Sorry, R. Chaudhary, Land Council for the appellant. The appellant plaintiff instituted TS number 60 stroke. So, yes, that. Thank you, Mr. Roy. Instituted TS 60 stroke to 2012 in the court of the Munsif number 1 Morigaon, claiming right title and interest
and
over a right title interest and
recovery.
delivery of and recovery of possession in respect of a plot of land measuring 1 bigha covered by DAG number 301 of PP number 56 under Kisam Nagabandha of Lahori Ghat Moza in the Morigaon district, which is the Schedule A land. Which comprises of the Schedule B and the Schedule C land. Equal for interest. To establish the right title and interest over the Schedule A land, the petitioners relied upon a registered sale deed number 2765/2008, which was exhibited as Exhibit 2. The learned trial court, in its judgment dated 31/2019, had rejected the registered sale deed by providing that the PW1 had not exhibited the signature of the executant Mohibur Rahman, and that there are various modes of proving a signature as provided in the Indian Evidence Act. And accordingly rejected the suit of the plaintiff. On appeal also rejected. On an appeal being instituted, title appeal being instituted before the court of assembly, being title appeal so number, by the judgment dated demand, it was rejected. In the present second appeal is admitted on the substantial question of law, Prem Corridio. In view of the law laid down by the Honorable Supreme Court in Prem Singh versus so-and-so, reported in so-and-so, paragraph 30, is it paragraph 31? Forgotten.
I will supply.
19, in paragraph 19 thereof. Sorry. In 27, not 19. 27, Mr. Roy. In 27. কি করলো? In paragraph 27, on which pronouncement in Prem Singh and others report versus Birbal and others reported in 2006 5 STC 353, whether there is a requirement under the law to exhibit the signature of the executant of a executant of a registered document, or whether there is a presumption of law in favor of its validity. Admit returnable so and so. In view of the prima facie case, the judgment stated, Vita judgment shall remain state.
Item 13.
If the appearance may urge upon further substantial questions law at the time of hearing.
Notice by registered.
Call for the FCRO. এখন থৈ দিব লাগি থাকে। Yes.
My lord, this is second appeal against the reversal judgment by trial court, my lord.
Mr. Roy, just check up the law once. I think when there is a registered sale deed being produced, there is a presumption of its validity. And if there is any doubt, it is for the other side to question it. Suppose it is a fraudulent deed or the signature is not of that man. It has to be specifically refuted by the other side, if necessary by means of cross-claim or another suit. But a registered document cannot be thrown away, that you have to burden will shift to the other side, not to the person projecting the registered document. Otherwise, I repeat, the dangerous situation. All that you have to do is to wait for the predecessor to die, who had purchased the land, occupy. No, that's what I'm saying. Suppose the vendor dies or the predecessor dies, and your land is occupied by somebody. You come and claim right title based on that sale deed. If now your dead man is required to be brought in to give evidence to prove that one, it will be a good case for that land grabbing act. Just occupy anybody's land. You know the father is no more. He cannot prove the sale deed. Occupy the land. It's I don't know. I think we'll have to take it up with the possibly. Just check up whether the view I'm taking is right or wrong. Because a lot of civil cases, this stand is taken. They invoke section 67 and then say that prove the registered sale deed. No, but they have to follow the law also. The only thing becoming is not good enough. Because 67, I don't know, my tentative view is in respect of only those documents which are required to be proved. Suppose today I rely upon a promissory note to claim some money against you. Then I'll have to, will also know. Will has to be proved because will is not registered. But the promissory note, the person making the note has to be examined. But registered document not required. Otherwise, the whole purpose of Registration Act is frustrated. Why do you get it registered then? Yes, Mr.
My lord, trial court, my lord, passed, my lord, we are dependent, my lord. Trial court, my lord, passed the judgment in our favor, my lord. It was dismissed, my lord.
Second
Then-
appeal, what is the substantial question
My
of
lord,
law?
page 5, my lord. My lord, though I have, my lord, noted a few substantial question of law, but I am, my lord, insisting on, my lord.
No, Mr. Borvea, there is a distinction between grounds and a substantial question of law.
Yes.
Every ground cannot be a substantial question of law.
Yes, my lord. Only, my lord, A, B, and C, my lord.
This is only a ground, not a substantial question of law. A. Who are entitled to claim enforcement of their subsequent alleged agreement. Yes, where is a substantial question of law?
My lord, in this case, my lord, they prayed for, my lord, specific performance, my lord.
Plaintiff.
Plaintiff.
Plaintiff prayed for specific performance of some agreement to sell.
Father, my lord, my lord, deceased father, my lord.
Your father made an agreement to sell
Agreement.
and they have filed a suit for specific performance. Then what happened?
My lord, in this case, what happened, my lord? Actually, my lord, this we are claiming this is my lord, forgery, my lord, fraud, my lord, because my father already, my lord, give one, my lord, Ikrarnama in the year 1886.
Achha, there's some prior agreement to sell.
Yes, my lord.
And this is a forged one.
Yes, my lord.
Where is your stand in the written statement?
This is, my lord, page 54, my lord. Page 53, my lord, first, my lord, 53.
What is this?
Page 53, my lord.
God is a written statement.
Yes, my lord.
Page 53, which paragraph?
First paragraph, my lord.
Co.
Yes, my lord. My lord, that the suit.
No, where is your specific stand? Where is your stand as a defendant?
This is our defense, my lord, written statement, my lord.
Where is your specific stand that the agreement to sell which is sought to be executed is fraudulent?
Yes, my lord, this is also, my lord, page 54, my lord.
We don't want any also. Show the specific stand.
54, my lord, my lord.
And Mr. Borhoy, please don't make me read the whole document.
No, my lord,
If you have taken the
this
stand,
is specific, my lord.
pinpointedly say that it is in so and so paragraph.
My lord, page 54, my lord,
Ummo.
that because of manufacturing agreement of sale deed, the defendant filed case of in the court of learned SDGM Hailakandi under section 7. And we are, my lord, admitting, my lord, this Ikrarnama. It is prior to that, my lord, and on
So
the,
this is your stand in paragraph number Ungo.
yes, sir.
Where are the issues framed?
issues, my lord, it is page, my lord, 14, my lord, in the appellate judgment, my lord.
A page 14.
Yes, my lord.
And how issue number 3 was decided?
Yes, page 16, my lord.
This is a appellate judgment.
Yes, my lord.
Where is it? Trial court was in your favor.
Yes, in my favor. My lord, on the basis of our past referendum, we have already executed land.
Just a minute. Now this agreement to sell is which exhibit? Exhibit number?
Exhibit 6, my lord.
6.
And our Ekranoma.
Just a minute. We'll hear you. So your stand is this agreement to sell is manufactured.
Manufactured,
Right.
my lord.
But just a minute. But the plaintiffs have proved the execution of that document by your predecessor in interest through the evidence of PW5. PW5 is the deed writer. Your predecessor put his signature in that deed in his presence. He has testified.
Yes, my lord.
So your allegation it is fraud
My lord,
has been disproved.
my lord, even my lord, assuming otherwise, my lord.
No
Suppose,
assuming,
my
nothing.
lord, if my,
So what is your next ground now?
my lord, because my lord, during the my lord, existence of one my lord, my agreement, within the period of that agreement, my lord, another my lord, this agreement cannot be, my lord. Because I gave the
Mr. M. Borbhuya, that means it is an illegality done by your father, number one.
Yes,
When he had made a bina in favor of another person, he made the second bina. Now, how can you take advantage of an illegality of your father?
yes, my lord. Therefore, my
That
lord,
ground also goes. Next round,
in the judgment, my lord, page 20, my lord,
Mr. Next round.
next ground, my lord, in the my lord, in such kind of cases, my lord, it is settled principle of law, my lord, that my lord, there should be my lord specific, my lord, averment in the petition, plain, my lord, that my lord, they are always willing to pay, my lord. But here in this case, my lord, they did not approach.
Where is the law that if that statement is not there, the plaintiff fails? Is there any judgment on that?
My lord, Lord, kindly will just last paragraph, my lord, paragraph 12, my
Hmm.
paragraph 12.
Paragraph 12.
And it is, my lord, in the section also. it is
Just a
provided.
minute. If you go on talking, how can I read? Either you allow me to read or you allow me to hear you. Which one you want? You don't want the court to read your judgment relight. Paragraph 12.
Last one. Before last.
See, Mr. Borguia, I don't have so much of concentration and intelligence like you. I either read or I hear. I can't do both simultaneously.
Sorry.
So if you want me to read, let me read. If you want me to hear, I stop reading, I'll hear you. Which one you want? Read. Okay, let me complete the reading and then I'll hear you. Otherwise, you are disturbing.
Sorry, man.
Where is the plane?
Plain, my lord, page 44, my lord.
Come to page 45.
My lord,
Come to page 45.
but where, my?
Accordingly, the plaintiff, by arranging the balance of money, approached the defendant to execute the sale deed, but they were passing time by various pleas. Under such circumstances, the last time plaintiff by his advocate sent registered postal notice that the plaintiff will remain present in the premises of Hailakandi with the balance of the money. So this statement is good enough to say that he is ready to execute.
my lord, only approach, my lord, 2 and 7, my lord.
Whatever it is, good enough. You are all having a common interest.
No, my lord, because my lord, father died, my lord, all are separate.
That is separation is your own internal family
Well,
arrangement,
what is
but
the-
otherwise the interest that you derive is a common interest.
My lord,
Two are good enough.
my lord, it was on this ground already this appeal was, my lord, admitted, but it was remanded back, my lord. Lordship kindly will look page 66, my lord.
60.
66, my lord.
Find out a good substantial question of law, we'll do it. We are not satisfied till now. What remanded back?
My lord, this matter, my lord, earlier filed, my lord, appeal, but on the, my lord, on
Who filed appeal?
we filed, my lord.
Huh.
But this judgment was not passed, my lord, as per law, my lord. Therefore, this matter was remanded back, my lord, to pass, my lord, judgment, my lord, as per law, my lord. On limited ground, it was remanded back, my lord. This is the
Where is
judgment,
the limited ground?
and this ground, my lord, page 66, my lord. Substantial question of law admitted, my lord, page 66, 1 and 2, my lord.
So this is once it is already sent back, second appeal. Why second time we send back? Let that man enjoy his money, land.
No, my lord, this was matter was not decided, my lord, but it was found, my lord.
Forget about past. Tell about the present. Present, we don't find any substantial question of law.
My lord,
Once remanded
It
back
was-
doesn't mean
it was, my
forever
lord,
it will be remanded back every
my
time.
lord, it was mentioned, my lord, on the limited ground, my lord. It
Where
was
is the limited ground?
Lordship page 69, my lord.
What you are saying, 166, 169.
My lord, without entering into the merit of the substantial question of law, my lord,
Huh.
it was provided to pass the judgment as per law, my lord.
And that's a very, very broad-based.
Therefore, my lord, this on
So
the-
do you expect now again, send back again process per law? The list Monday, petitioner to make out any substantial question of law that may involved in the present appeal. Firstly, the petitioner takes a ground in the written statement that the Exhibit 6 agreement to sale is a fraudulent document, but it is a categorical finding of the learned appellate court that PW5, being the deed writer, had deposed before the court, had proved before the court his signature as well as the signature of the predecessor of the defendants, meaning thereby that the standoff that the document is a false document stands negated. The second ground urged upon by Mr. A. Borbhuya, Learned Counsel for the appellant, is that the agreement to sale involved in the present appeal is a second agreement to sale made by his predecessors, made by their predecessors, and therefore in respect of the same land, and therefore it is not maintainable. If it is so, apparently the predecessor interest of the defendants had committed an illegality, and an illegality under the law cannot be a reason to take advantage at a later stage, and hence would be unacceptable. The third ground urged upon is that in the plaint, the plaintiffs had not categorically stated that they are willing to execute and do the needful pursuant to the agreement to sale for which the specific performance should have been instituted. But a reading of the plaint makes it discernible in para 2, makes it discernible that it's a categorical statement that they have arranged the balance of the money for execution of the sale deed pursuant to the agreement of sale, and they have notified the defendants to remain present in the office of the sub-register for executing the sale deed and to take the money. The statement is clear enough that it is an averment by the plaintiff that they are ready to execute the sale deed. this ground is in reference to the proposition laid down by the Honorable Supreme Court in para 12 of its pronouncement in Abdul Qadir Rothar versus P.K. Sarabhai and others, reported in (1989) 4 SCC 313, wherein it is provided that for a suit for specific performance, there is also a condition precedent that there must be a averment in the plain, that the plaintiffs are willing to execute the agreement for sale for which the specific performance suit has been filed. From the above contentions raised by the Land Conservation, no substantial question of law is discernible. Mr. Bhuya seeks for an adjournment to examine as to whether any further substantial question of law is available. Let's next week, date will be given.
For filing appropriate.
You
2 weeks time, but
want to file
yes, ma'am.
application?
Yes.
Mr. J. Saikyal and counsel for the, this is an appeal or what?
It is my lord, there is a delay condonation petition, ma'am.
The I is for condoning that
Yes,
delay.
condonation. Another is a stay of order proceeding of the suit, and another is delay condonation.
Can there be a substitution in delay condonation?
My lord, as per my instruction, my lord, the years of the
No. Can there be a substitution in a delay condonation petition?
lordship may strike up the name of the.
I'm not asking you what I should do. I'm asking you, can there be a substitution in a delay condonation application?
Substitution is not required.
No. Please listen to the question. Can there be substitution in a delay condonation petition? In an appeal, yes. Because one appeal is filed by X. If X is no more, that appeal stands abated. So the legal heirs of X will come and say, please now implead us as the appellants in place of the deceased appellant. But in a delay condonation application, is there a provision for substitution?
I think no. As because the years of the applicant number 1 is already been there. Others legal heir, legal representative of applicant number 1 is here, my.
Where? In this IA?
IA also. Therefore, my lord, substitution is not required.
Who had filed this IA? Makoni, who is Makoni? Makoni, Noren, Sorot, who are they? They are the legal heirs of the appellant. And who is the appellant?
All are the appellant. All are the appellant. 1 to 7 are the appellant. They are the defendant in the suit.
Understand? So, this prospective appellant, he died before the appeal was filed.
No. After filing.
Then why Makoni is the appellant then? Makoni died.
Makoni died on September 2020.
Okay, Makoni died.
Makoni.
Very well. And
applicant
and
number,
who are Noren, Sorot, Montu, Bokul, Anil and Krishna?
all are the son of Makoni.
They are the legal heirs.
Yes.
So whom would you want to substitute?
Substitution petition is not required.
Not required.
But,
So you say
strike out the
we
name of
simply delete Makoni. That's all.
Like-
Because the appeal can be carried forward by the other legal others.
Right.
And this IA is for condoning delay. How much of delay? I can't file Why have you filed this IA? Prayed for admit notice to why delay of 113 days shall not be condoned. This is purpose. Yes, are you objecting to condoning the delay?
Yes, to be filed an affidavit in opposition.
On what ground you are opposing? On what ground you are opposing this condoning delay of 113 days?
That should be in para 9 of my affidavit in opposition.
What have you stated? Hmm. Earlier one appeal was filed.
Yes, my lord.
That was defective.
That was defective and dismissed against the serial number.
Ha,
I approached my lord before the registry, my lord.
I understand. Dismissed on 19/12/2017.
Yes.
Once the appeal is dismissed, how can you file another appeal?
My lord, it was dismissed against serial number. Appeal was not numbered.
Doesn't matter.
Appeal was not numbered.
May not be numbered, but it was dismissed.
And registry.
Once it is a dismissed, the number may be different, but your appeal is dismissed for whatever reason. Then how can you maintain another appeal after the dismissal of the appeal? There is no law that res judicata will be applicable only after numbering.
Then my lord, I may be allowed to file application on returning of the
I
plane,
think
my lord. As because.
Returning of the plane.
Yes, my lord.
This is appeal. This is not a suit.
Appeal, my lord. This is correct, my lord, but registry.
I think the only way out for you is to get that order recalled.
And lordship as per order dated
Please.
26.
He is submitting, no disturbing. Where is that order? Page number 1912.
My lord, that order was not obtained by.
Can I take a look at it?
That was not along with me, my lord, but the whole.
No, was
file-
it an administrative order or it was a judicial order?
My lord, Lazima court, my lord, says judicial order. The whole order is not allowed with me, my lord, but the copy of the earlier appeal.
No,
Six-
copy I don't want. I want the order.
Order I have.
Or did the court give any liberty to file
Simply
a...
it was dismissed, my lord.
See, your appeal was dismissed that it was a defective.
Defective.
Appeal memo was defective or something like that.
Yes, my
Dismissed. Did the court give you liberty to file a corrected appeal?
no, my lord, there is no any reflection, but when I approached before that.
Then your only way out now is to seek a recall of that order. Once the order is recalled, we will consider whether your appeal should be, whether it was a case to give you time to rectify the appeal, or it was a case for dismissal of the appeal, we'll consider that. But once an appeal is dismissed, for whatever reason, res judicata will be applicable.
I may be allowed to file
Think-
appropriate application.
Think over it. between the parties and the issues must be decided. But defecting appeal is also a decision on the issue. We adjourn it, you look into the whole thing. And that appeal was filed by the deceased person.
Yes,
That was filed by whom it was filed?
all the applicants.
This Makoni and others.
Makoni.
And after that was dismissed, you have filed this present appeal?
Yes.
Along with a condonation application.
Earlier question of limitation was not.
Definitely.
It was filed within the time.
So it is stated that prior to the present appeal being instituted, the petitioner, the appellant had instituted an appeal on the same cause of action against the same parties, which was yet to be numbered. But by an order dated 19/12/2017, the appeal was dismissed for being defective. The petitioner to produce a copy of the order details by which earlier appeal was dismissed.
My lord,
You apply for it.
in another appeal, my lord, there is no any order as such. I searched, my lord. And the earlier appeal, my lord, there is.
Mr. Saikia, your earlier unnumbered appeal will be available in the record room.
Record has been returned to me, my lord. That is the problem, my lord. Record has been returned to me, my lord. I have just check slip and serial number along with the court fee.
This was the earlier appeal. Where is the office note of returning it to you?
Perhaps it may be order sheet, my lord.
Get that order. We'll examine the order, what kind of order it is, and then think.
Item 15.
Same way. 15 is
15,
also
same.
same.
15 also returned back.
Returned back. It was also dismissed against serial number.
Let us read that order, then we'll understand it better.
Item 16.
Yes. IFO, for what purpose?
Delay, for condonation of delay,
How many days?
62 days.
Objecting?
Lordship,
Why?
Lordship, I'm appearing for response number 1 and 2. Response
And
number
why are
3,
you objecting? On what ground?
in paragraph 4 of the IA Lordship, page 5 Lordship. Paragraph 4, page 5 Lordship. They have stated that the applicant decided to come to Guwahati on 1/10/2020, but unfortunately the applicant met with an accident. Lordship, all the-
Paragraph number
paragraph number 4 Lordship.
4. So now,
Lordship, all the medical prescription, they are of, he is suffering from illness, Lordship, and nothing has been disturbed regarding accident, Lordship. The medical prescription, they are of illness, Lordship.
do you have any knowledge that he did not meet with an accident?
Lordship, kindly review page.
Understand, you are only questioning,
No,
but
Lordship.
you are not objecting. May not be, you can ask him to produce any material to show that you met with an accident.
Lord, I have to take instruction from the petitioner, my lord, regarding that.
Your name, please?
My name is C. Sharma.
Mr. C. Sharma, and call the applicant raise for an adjournment to produce any relevant material as regards the accident that the applicant may have met as stated in para 4 of the interlocutory application eh, on the situation that MSS as tasked land counsel for the respondents has objected that no material had been produced by the applicant regarding such accident. List again. Ms. K. Bhogan from next.
Service is not completed in respondent number 3 and 3A.
Lordship,
And the
respondent
order
number three
dated,
expired, Lordship.
Hmm?
3 expired.
She died.
but my lord, we could not be able to get the information that when the respondent number 3 died.
8/9/2020. 8/9/2020.
It is also stated by MSS that and counter for respondent number
3.
3 that the who died.
Respondent number 3, Lordship.
Then you are appealing for whom?
1 and 2.
1 and 2. The respondent number 3 died on.
8/9/2020.
Full stop.
And moreover, my lord, in our petition, there is respondent number 3A. And as per our information, respondent number 3A is the legal heir of respondent number 3. But the report says that no such person is
Here,
there.
go to the Lajima court. The matter may be placed before the Lajima court for certain issues being raised by the learned counsel for the petitioner as to whether respondent number 3A is the legal heir of the respondent number 3.
They can also provide the
Next
information.
Lordship,
Are you not wasting time for others?
No, your
You make a request to her. Why do you need a court order for that?
highly obliged.
Madam Das has informed he died. If you want to substitute, make a request. Please give me the name of the. Let me take up the other matters. Many people are waiting. Yes.
Item 18.
18. Mr. Bush.
All right, this matter is ready for hearing.
RSA.
I had already
You are
stated,
you are ready.
and respondent number 1 to 10.
Are you ready for the hearing?
Matter is ready, LCR has been discussed.
Matter is ready. Are you ready?
Today I am not ready.
You are not ready. Mr. G. Boysol, appellant states that the matter is otherwise ready for hearing, but Mr.
A. Hussain.
A. Hussain, land counsel appearing for the respondents, number 1 to 10 states that some further time would be required to the land counsel to prepare the matter. View such statement, list on.
512. Item
Next, you
19.
come ready, we'll hear you.
After vacation.
Eh, Did you hear what he said? No, summer vacation.
Sorry, winter. Summer.
Yes,
In this matter, I am the sole respondent, my lord.
Huh.
Regarding service, it is complete, my lord.
Huh.
And L4 also, my lord,
Received.
received.
Hmm.
So, my lord, may I pray for some accommodation after 1 week or 2?
After 1 week. Adjourn on the prayer, Mr. M.J. Kadir, land counsel appearing for the
So,
respondent to be listed again.
Offline, pray for listing in the admission column.
Item 20. After 1 week.
As long as before me, column doesn't matter. What matters is you should be ready with the hearing.
Offline.
That's all. Yes, Mr. Uddin,
Service completed matter.
you are entered appearance. What to do? Can you hear it today?
No, Lordship. It's
Not
for
today.
another day.
Okay, MS
A beg.
A. Begum, land counsel enters appearance for the respondents, all the respondents, and prays for an adjournment. Pray aloud. List.
Item 21.
Offline.
21 who is appearing. None appeared for the applicant on 4/8. You are there.
I don't, my senior is in the other court.
We don't know. Either you argue or we close it.
My lord.
Because your conduct of your senior is not very good. For the last 4 or 5 days, he is absent without any reason.
My lord, please give me some time.
So we may not favor you with an adjournment today. What is the matter? What about the main appeal? Has it been NN Upadhyay, EAPS correspondent. It is taken note that none appeared for the applicant on 4/8/2023. And 4/10/2023, today when the matter is called and adjournment is sought on the inconvenience of Mr. Who is a senior? Who is your senior name?
My lord,
You are a senior.
yes, I am language.
For whom do you appear?
And for the opposite party.
Opposite, who appears for the applicant?
He doesn't know.
Then why you stand?
not
Again on 4/10/2023, none appeared for the applicant. Today again none appears.
Yes.
I
Maybe this.
Civil 1902/2022 stands dismissed for non-prosecution.
22,
Yes,
Actually, I'm for the petitioner. Actually, due to our mistake, we could not take steps upon respondent number 1 and 3.
your name please?
Noinjyoti Das.
Mr. Noinjyoti Das appearing for the applicant in IS Bill 5282.
Yes, sir.
20 states that inadvertently the steps could not be taken and prayer is made for grant of further time to take steps. Pray allowed. Required steps to be taken within 2 weeks.
item 23,
Union of India has asked for the applicant.
Lord Chief, I have appeared on respondent number 1, 2, 3, and 4, Lord Chief. I have filed, I will file objection in IA, Lord Chief. So kindly.
IA is for what purpose?
On the
How many deal?
24 days, Lord.
24,
Lord. We have 21 days, Lord.
21. What ground do you intend to take?
Lord Chief, I have
No. What ground you intend to take to oppose condoning delay of 21 days?
I have no.
His senior is, her senior is from the today. He told me that her senior is from difficult store.
So you take an adjournment on the absence of your senior. But 21 days, what possible ground will you take to object? Tell me that.
Okay, Lord.
MS
J. Kolita.
J. Qualitas seeks for an adjournment on the inconvenience of who is your senior?
Mr. D.C.K. Hazari.
On the inconvenience of Mr. C.K. Hazarika. The present application is for condoning a delay of 21 days.
24,
For this, that matter, no?
Yes.
Let's adjourn it today. We had asked the registry to take it up on the administrative side on certain aspects. And in fact, I was little late in sitting because of that only. Let them respond what they
Exactly.
want to do.
Actually,
Because we are finding certain difficulties in this matter. One aspect, the criminal matter was placed before that assistant session judge to consider whether that particular convict or under trial should be released on bail as per the requirement of some Supreme Court order. High Court judicial order or administrative order?
judicial.
Okay, judicial order, he is required to take up. So the court will decide either he should be released or he should not be released. The court had totally forgotten about the judicial responsibility. That court becomes very perturbed with a letter written by the Secretary DLSA.
No, that was asked for.
Whether we asked or not, he is getting very perturbed with the contents of that letter.
Well,
Ultimately,
he passed the judicial.
he passed a judicial order deciding the contents of the letter,
Well,
totally forgetting the original judicial responsibility,
purpose.
whether the man should be released or not. Man is still behind.
Man is still behind, no, because.
So now will it be not a case of habeas corpus against that man? And habeas corpus against whom?
No, my lord, he is that so far, my lord, the record available, I
Mr. Mohanto, if he is not entitled to be released, there should be a judicial order justifying why he should not be released.
Exactly.
But there is a requirement of a judicial order as per the order of the Supreme Court and order of the High Court. So, till you consider on the judicial side on whether he should be released or not, further detention is an illegal detention in view of the Supreme Court order and the High Court order. Once you consider and say that fact circumstance of this case does not warrant a release, end of the matter, you keep the man in custody, we have not difficulty. But when there is a requirement of law to take a judicial decision whether he should be released or not, and the judicial authority does not take a decision on the actual issue, further detention is illegal. So this will be a case of, from one point of view, looking into the case of habeas corpus. Mr. Nath may oppose his release. You may have many reasons, but that has to be judicially decided.
But these are matter what I have got. Bail order has been passed, but because they could not fill up.
This is the issue, Mr. Nath. This is the issue we are trying to ask you. There must be a judicial adjudication as per the terms of the Supreme Court order and the High Court order, that whether without any bailer, surety, etc.,
condition, he can fulfill
or any condition, this man should be released or should not be released, and if yes, in what manner to release. This is a judicial requirement. If the judicial authority does not take a decision, goes to some other ancillary issue, and close the matter of releasing there, further detention is unconstitutional. Number one. Not in absolute terms, but in relative terms, because of the. This is one way of looking at it, number one. Number two, this is a CRP listed before this court on a suo motu, because one DRSA secretary says that as per requirement of law, I had written a letter to the assistant session judge. But the assistant session judge made some disparaging comments against me in his judicial order.
the expansion of that.
So simple matter is getting so complicated for nothing.
Why?
This is number one. The secretary writes to the Chief Justice complaining against the disparaging comment. Chief Justice said, list it on the judicial side. So here is a suo motu revision before this court. In the suo motu revision, rightly or wrongly, that assistant district judge is made a respondent. That is again another issue, whether he ought to have been made or he ought not to have been made, especially in view of that 1986 Act. No, you'll say, don't worry. We'll allow you to say whatever you want to say. Let us make the background clear first. The judicial officer, after being made a respondent, he's a litigant.
He's a litigant.
Rightly or wrongly made a respondent, he's a litigant. He cannot be anything beyond a litigant. Once he is a litigant as a respondent, High Court rules requires either he will personally appear and address as the issues against him, or he will engage a lawyer. And whatever he has to say by means of an affidavit or orally, whichever you say. This person, instead of doing what is required, writes a huge communication to the Registrar General. He gives a copy of the communication to you also possibly. Maybe Madam Chatterjee, Madam Chakraborty has also received that communication.
Yes, sir.
Now, what is the legal implication of a direct communication by a litigant to the court? Is it acceptable in law? No.
No.
It's a kind of a, in a way, if you look at it, you are trying to influence the court for a judicial decision.
Time and again, lordship is
Huh.
explicit.
Had the ordinary litigant done that, he would have been, contempt would have been brought against him by now.
Correct.
But it's a judicial.
Correct.
Not only that, the learned senior advocate had been, his esteem had been lowered down to the extent that a communication of this order had been served upon him through a process server, Jari Karak. These are some of the matters required to be taken up on the administrative side.
Administrative, lordship, little bit better.
That has to be taken.
Number one. And if the respondent number 2 and 3, if he feels that he was incorrectly arrayed as a respondent, what is the remedy open?
In any case.
File an application
in
to
any
delete
case,
him.
The applicant, the respondent has to come and say,
No,
ultimately the affidavit.
if an application comes, please delete me.
Yes.
I should not be arrayed as a respondent in view of this act. We'll delete him.
Yes, yes. That the person has to come and.
And for removing the disparaging comment against somebody, you don't need to hear the judicial authority. There's no requirement of law.
No requirement of law, then.
That's why I say the simplest of the matter, which in one day it could have been solved, expunge the disparaging comments, had been made so complicated by all the subsequent events.
Yes. Because of registration of the CRP and.
No, registration is okay. We need the registration of CRP to expunge the comments.
And
It
communication.
can be done only in a judicial side because it's in a judicial order.
Communication of the letter.
Hmm.
Because of the communication of the letter.
Now what to do?
No, from the.
Let us wait. This
Now to
again in the next.
Now to notice by the.
No, Pisces, he is only here.
Yeah, দেখুন কালে করবো। আজি, আপনার আগে বার করবো। Wednesday, we are listening. An original application, Mr. Mohanto, it's a one paragraph answer.
My lord.
We expunge the
Yes, no,
disparaging comment.
that must, my lord, without impeding that, my lord, it can have been done.
Only the subsequent events had made it a unnecessary mess.
I have seen the latest Supreme Court order also. I have seen that only one. I have seen.
One paragraph.
So it is not required to hear hard, my lord.
And
That
the judicial authority is not required to be heard.
hard, not required to be. So without going to that all complication, my lord.
But once it is implemented in a judicial order, can I recall it, suo motu?
Now, that is, my lord, by a judicial, yes, that order passed by a coordinate bench.
This is what I was thinking about. I can't suo motu
Yes, my lord.
recall that order
In a-
unless somebody makes an application.
Or oral request can be done. If he appeared and oral request can be done, that can be done. So probably without going to that, my lord, at the side that can be, my lord. He either he throw one advocate or, my lord.
Anybody.
He can appear personally also. Well, like fix it on another date, I'll advise, my lord. Probably he also.
But this directly coming in a court, we cannot.
Yes, it will
That is
it will
not
be
acceptable.
another, my
That
lord.
is not acceptable.
Because
Proposition.
today I accept it. Tomorrow a man in the street will also come to me
Exactly,
and say
my
this
lord. Yes,
thing.
why
And if
not?
I object, you say this is your judicial order.
That will be difficult. man.
Every litigant should be given a personal hearing by the
Yes,
judge,
I mean, but yes.
by the judge out of the court also, in every case. You can't
So,
accept it.
Can he fix another date? We try to, my lord. Probably he can also.
And what did you want to say? You wanted, try to say something?
While passing the order, he has just on merit of that, Malad, the person concerned who was sought to be released from jail, Malad, the.
No, I read that order. There is nothing about him.
No, while passing the order, he said that he was given he has passed an order granting him bail, putting a condition, and that was before filing charge sheet. Since charge sheet is already filed, that has no consequence. That is why there is a misrepresentation by the Secretary DLSA
seeking amendment in the bail condition. That is what the ultimate finding of the court.
So the judicial order could have been requiring this
Rejection of
man
the petition.
inside that as charge sheet has been filed, now he make an application before the court dealing with the criminal trial.
He is dealing, bro.
Who is
He
dealing? He himself is dealing
He
it.
is himself is dealing. He is dealing. That is why the application was filed before him for his release.
So now what did he do with the prayer for releasing?
He has rejected the application of the
On
secretary
what
DLSA.
ground?
This is the order, my lord, by.
I read it. On
by-
what ground he rejected?
That is not reflected.
That
He
is not-
says that
that is
they
not-
granted earlier automatically.
He has rejected because he is not happy with somebody else.
Somebody else's letter.
Huh.
Correct. The ultimate
So
issue
how-
remains.
That
So-
Hmm.
Today, Mr. Nath, I engaged Madam Chakravarti to make some inquiry or submit a report to the court. Somehow I am not very happy with what Madam Chakravarti said.
Yeah.
Will I not pass an order in his petition? Or I'm not happy with what Madam Chakravarti says, reject this petition. It cannot
Some
be.
remark has been made to the inquiry officer and the matter has been left at that stage.
Huh.
So that has to be
So
looked into.
we are asking what happened to the litigant?
Nothing.
Where is his right to be considered under the
Correct,
law?
correct. So main issue has been, well, it has been,
Yeah, main
Over-
issue has
over.
not been addressed.
it has been over.
Yes, fully over.
So that is, don't you think it is an illegal detention of that man?
Detention, matter ultimately some application has
See.
to be, has to go to the court.
Imagine it's a bail petition,
Matter.
okay? I do everything else other than deciding the question whether the man should be released on bail or not. I take note of every extraneous factor. If I don't decide the bail application, I may take a little longer time to decide a bail application. That is something different. You need no material, this, that. But after doing everything, am I not required to decide the right of that man to bail?
Where he is entitled to get bail.
Huh.
That has to be.
And if I
that-
don't, and I simply close that petition without anything, every subsequent day of detention will be an illegal detention. Look at the law from a little
Yes,
brother perspective.
Yes. Since my lord is taking up the matter at the administrative side.
And what is
only
the date of this order?
April
5/4/2023.
April 23.
So from April 23, this man is not getting a due consideration whether he should be released on bail or not, on his own merit. Because of, there is a difference of view between a court and a man, another officer submitting a report.
Yes,
The original man whose bail is to be considered is not getting a due consideration. What is happening?
Exactly.
but since lot of persons are there in jail, but they are not in a position to file application for their bail. That is why the honorable court has
That's
suggested the DLSA that you file application for them so that they can get the benefit. In that process, one of the application was filed by DLSA.
Right. Suppose in the application DLSA writes one line of incorrect fact also.
That cannot-
Core requirement is to consider the
Consider
bail,
the-
Yes,
not to decide on the correctness of an factual statement in an
Exactly,
application.
ma'am.
That is not the purpose of this proceeding.
absolutely not, absolutely.
He is not on a disciplinary proceeding against that man.
It seems that he is doing that only. So like Lordship is since taking up the matter on the administrative side, this has,
No, why we are little worried about the,
record can be called for.
I think no, I think we'll have to pass an order directing the assistant, yes, to consider the claim of bail of that accused. He is an accused, no? Accused or convict?
UTP.
UTP.
Under
Under trial as per law. This litigation cannot keep it pending.
This is a separate thing. No,
It's a separate thing, my lord. It
This
is
is
not to do with
something-
my lord. Probably by this time, what happened in the criminal case
And
will not-
where is the order?
Order
page
page 53, my lord.
Page
It
51
start from
starts.
51.
51.
Second-
Where does it end?
Second page onwards, kindly see, my lord. First one of this is relevant, my lord. It appears that the aforesaid letter is in response to a direction issued by order dated 33.
No, no, page number
Page 51. Annexure 10.
T1.
Case record put up before me today on the basis of letter number so and so dated 4/4/23 issued by the Office of the District Legal Service Authority, Dhubri. Seen the same, it appears that the aforesaid letter is in
One
response.
thing. Again, this is a civil revision.
Yes, civil revision, that's why, my lord. But even then, my lord, it can be converted under 227, my lord. But by this time, because
No, I think there's a necessity. Necessity to convert it to some other things and also take a call whether this man should be released or he should not be released.
so that, my lord, you have to take.
Because unnecessary because of this
Unnecessary,
one,
because of this sub-suit, my lord.
that man
he
is
not
inside.
suffer. He should not be suffered, my
He
lord.
doesn't know anything.
Yes, my lord.
Somebody writes a letter, somebody is not happy. Those two are,
So on that, my lord.
and this original man, he is inside.
But, Lordship may direct the session just to look into that matter and decide as regards the bill, because the case is pending there.
But
So that is that, what is the status of the session case, my lord? That has to be, my lord.
Bail expect to district level, sir, it doesn't really file or anything, right? That in the minimum file of. No, no. Civil bail expect to different file of anything.
Under what section?
420, 120B, 420. One 120 or 420. Page 19. Serial number 3. Serial number 3. Project done.
120B, 420.
this is judicially incorrect. That so and so appears to have ignored the settled position that once accused has failed to exercise his right to furnish bail bond, then his right to get released extinguishes and the bail granted stands automatically cancelled. How can you say that when the Supreme Court has asked you to take note of all these cases?
That is totally, my lord.
In fact, court has directed that to release those persons,
When
the
the
condition
PR
is to be reduced.
That's why when
That
the
is-
Supreme
that is
Court
the
has
purpose.
directed,
That is the
No,
purpose.
no, that what, that.
how can you take note of some presumption of law as per your imagination?
The automatically
Be
cancel,
that
my
as
lord,
it
that
may,
is,
the apparent,
the bail granted, then automatically cancel. As such, no question of
maybe bona
would
fide
arise
should
the
be
modification of the alteration of the any
considered
condition of the
something
BR.
good advice.
In fact, court order modification করে court number one.
This suo motu revision is placed before this court. On the basis of, where is the note of the Honorable Chief Justice?
That, my lord, you will have to put
Mhm.
page.
Page 64.
Page 64, my lord.
64, on the basis of,
63.
on the basis of, administrative order by the Honorable Chief Justice requiring a suo motu revision to be registered and listed before the appropriate bench in respect of a letter written by the Secretary DLSA Dhupri seeking to expunge certain remarks made in an order dated 5/4/2023 in Sessions Case 36/2022. In doing so, in the present revision petition by an order dated 29/9/2023, the judicial authority who had passed the order dated 5/4/2023 in Sessions Case 36/2022 had been arrayed as respondents number 2 by designation and 3 by name. In the meantime, the respondent number 2 and 3 judicial authority had made certain communications. One directly addressed to the Registrar General, to the Registrar General of the court, another to the learned counsel appearing for the other respondents, namely the Assam State Legal Services and the State of Assam. A further copy of the said communication of the respondent number 2 and 3 had been served by a process server upon the learned senior counsel appearing for the petitioner. Full stop. In the circumstance, there is a requirement of the matter to be taken up administratively as to whether, although the respondent number 2 and 3 may be otherwise a judicial authority, but in the present litigation is arrayed as a party litigant. And in the circumstance, being a party litigant, whether it would be permissible to directly communicate with the Registrar General as well as the other respondents, and more particularly with the learned counsel for the petitioner. In the aforesaid complication of the matter due to the subsequent events after registration of the suo motu revision petition, which originally merely requires a judicial decision as to whether the disparaging comments are to be expunged, the matter stands as such. The order dated (5/4/2023), which page it was?
Page 51.
51. The order dated 5/4/2023 in Sessions Case 36/2022, wherein the alleged disparaging remarks or comments were made, pertains to a judicial determination to be made whether the accused in the said Sessions Case 36/2022 is to be released on bail, is to be released from custody. Because bail, somebody say already granted or not. The said consideration had arisen in the background of where's the Supreme Court judgment? In the background of a Supreme Court order dated
Page, my lord, 30. Page 13.
The background of the Supreme Court order dated
31/1/2020.
31/1
2023.
2023 in SMWP bracket criminal number 4 2021, wherein
Page 36.
relevant paragraph.
Para 6, my lord. Five and six.
No, paragraph numbers are not there.
Page
Then the last page there is
Where, okay, wherein in paragraph 6 of the directions issued by the Honorable Supreme Court, it had been provided as a paragraph
if the bail bond is not furnished
6
within 1
number.
month.
Just a minute, Mr. Monta, keep a look. 5 and 6, it is provided as extracted. No, very provide গোটেইকেইটা দিব লাগিব 5 and 6 নহয়, all from 1. From 1 to
Yes, from 1 will be
I
there,
think
yes.
everything will be there.
Everything will be there.
The requirement of the directions of the Honorable Supreme Court is that if a court grants bail to an under trial prisoner stroke convict, it would be required to be provided with a soft copy of the bail order. And if the accused is not released within a period of 7 days from the date of grant of bail, it will be the duty of the superintendent of jail to inform the secretary DLSA, who may depute paralegal volunteer or jail visiting advocate to interact with the prisoner and assist the prisoner in all possible ways. The further requirement would be of the secretary DLSA to find out the economic condition of the accused, and for the purpose may take help of probation officers or the paralegal volunteers to prepare a report on the socio-economic conditions. In cases where the under trial or convict requests that he can be furnished a bail bond or surety once released, then in an appropriate case, the court may consider granting temporary bail for a specified period to the accused. It further provided that if the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case and consider whether the conditions of bail require modification, relaxation. In other words, the very purpose of the directions of the Honorable Supreme Court is that in the event under trial prisoner or a convict is unable to furnish the bail bonds, what further actions are required to keep him in further custody, or there is a requirement to release him? Pursuant to the Honorable Order of Supreme Court, there is also an order of the High Court in dated so and so for the same purpose. Dated so and so case for the same purpose. The order dated 5/4/2023 of the learned Assistant Session Judge in Sessions Case 36/2022 came up for a judicial consideration precisely for the aforestated purpose as to whether the accused person involved in Sessions Case 36/2022 is required to be released on bail upon having not been able to furnish the bail bonds. The letter referred in the order dated 5/4/2023 is pursuant to a requirement in the aforesaid direction of the Honorable Supreme Court requiring the Secretary DLSA to submit a report. It appears from the order dated 5/4/2023 that the learned assistant session judge had completely lost track of the requirement as to why the matter had not gone into the aspect as to why the matter was placed before the learned court on the judicial side. But on the other hand, had ventured into the contents of the letter written by the Secretary DLSA, which the learned assistant session found to be inappropriate in the manner as indicated in the said order. The aspect of the manner in which the learned assistant session judge had dealt and the observations made therein on the letter of the Secretary DLSA would be considered in course of the present civil revision. But what we are constrained to observe that in the background of the aspect regarding the contents of the letter of the Secretary DLSA, as reflected in the order of the learned assistant session judge dated 5/4/2023, the purpose for which the sessions case so-and-so 36/2022 was listed before the learned court had been deviated from. The only observation that is made, where is that line? It was rejected.
It is, my lord, page 53, my lord, para, there is no para. The bail granted stand automatically cancel and such no question of
Is that it was dealt with in a relevant paragraph, which is extracted as below.
Last portion of
It appears that the learned assistant session judge is of the view that the law provides that once the accused has failed to exercise his right to furnish a bail bond before filing of charge sheet, then his right to get released extinguishes and the bail granted stand automatically cancelled. No factual satisfaction had been recorded that in the meantime, after grant of bail and upon the accused being unable to furnish bail bond, the matter had been charge sheeted. It must be charge sheeted, otherwise sessions case. Has the accused made any further application for bail?
That information will be.
But then how can he be released otherwise?
Some application has to be made. DLSA can file an application.
DLSA party.
In the background of the directions of the Honorable Supreme Court, that an accused should not be, that an accused, if unable to furnish the bail, should be given some further considerations, it would be more appropriate to can DLSA do it?
The DLSA will file an application
For regular bail?
for that actually condition, waive out the condition.
No, that condition has become infructuous
Now
because he
because
is
of this
charge
order.
sheeted.
For his release, my lord.
For his release.
And
No,
file
no.
application for a bail.
After charge sheet, it will be a fresh bail petition. That has become infructuous, earlier bail order.
Now
Bail order as a under investigation, stage of investigation, that has become infructuous because that order is no longer holding the field.
Then,
Now there has to be a fresh bail application.
Fresh application.
Fresh application was done for 1st of September.
MS P. Chakraborty, counsel appearing for the respondents in the Assam State Legal Services, has informed the court that a bail application dated
Was filed on 1st of September.
on 1/9/2023. What happened to that?
No, no.
Jail for it.
Oh, he has been convicted.
He has been convicted.
Huh?
Convicted.
He has been already trial government.
No, very information that in the meantime, the accused in Sessions case 36/2022 had already been convicted as per the judgment and order dated. It will record kori thoi diok, thako.
Fine. Record kori, then he will connect.
And the other one, this one will decide it. Mr. Ghosh, you are aware of this matter?
Yes, yes, yes.
You have seem to be
This is the-
having a lot of factual information with you.
From
Okay,
website just now, my lord, he from session case number 36 of 2022, that is disposed of on, my lord, 1/9/2023.
He had been convicted. Record kori thoi diok.
Because he is informed that about the right of the appeal against the, yes, convicted.
Convicted. If convicted, it is over. Then they'll
That
go
chapter
to
is over.
that will
Only
go
that
to some
expansion of the sentence will be in that year, my lord.
expansion. See,
Only one.
one paragraph matter could have been over long back. No, that will follow its own course.
Yes, my lord. Then there is you can file appeal here.
And maybe the amount of time this man is behind, that 3 years sentence may have already been served out.
My lord.
He already served out the sentence.
It will be said off.
Mm. That too under the Foreigners Act. Is a trial under the Foreigners Act, not even a regular offense. A list we are not passing any order. List on Wednesday. Why, if he is already trial over, why go into all those things? Need not go into that aspect. Khali eta line likhi thoi dibo, that we have been, that is regarding the Omukomo in view of the Supreme Court judgment. We have been informed that in the meantime, the trial is over and by the saying the accused had been convicted. Okal hetu line likhi thoi dile hobo.
Item 25.
My lord, in case one mistake is there, my lord. Page 18 is missed out. So I may be allowed to.
I understand that. No, once notice is issued, other side appears this thing, it'll be more of a case of amendment of the petition, more than a correction.
It is in annexure, my lord,
Hmm.
not in petition.
Amendment of the entire thing, the whole thing is a petition, including annexures. Are you objecting? No.
I'm telling the plain. Not
Are you objecting? Heard Mr. S.K. Ghosh, land counsel for the petitioner. Also heard Mr. D. Chakraborty, land counsel for the respondent. You have filed I.
No, I have not.
Oral prayer is made by Mr. S.K. Ghosh, land counsel for the petitioner, that inadvertently page 18 of the petition comprising of the annexures was not incorporated in the petition, and the learned counsel seeks to incorporate necessary correction. Correction may be made in the presence of the registry. I think this is sufficient. Mr. D. Chakraborty does not object to such corrections as to be made as sought for.
26. Please second.
Yes, Mr. K.K. Bhatto.
Their name is stated, but they have not taken. I have to take this statement
Fresh steps upon whom?
for all the rest.
Mr. K.K. Bhatto, and counsel petitioner, makes a prayer that the applicant be allowed to take fresh steps on all the respondents. Pray a lot. Steps may be taken by registered post within 3 days. Want to serve Dusty? Dusty 1. Only registered.
27. 3 weeks per hour.
Yes, sir. The jury.
The Lordship may kindly peruse the order. Order is 7/11/2023.
Today, what we do? Order dated
7/11/2023, Your Lordship.
7.
Press step,
There is no order.
no. Office note, Your Lordship.
Office note.
Office. I'm extremely sorry.
So usual process server already served.
Yes, sir.
Office note of 7/11/2023 provides that notices sent by usual process to the had been served upon the respondents number 127 as per the report of the process server available at flag X. How do you appear?
Appearing for respondent number 1.
Only one, not others. Others, they won't engage you. No.
Lordship, I have no idea.
Who are they? They are related or?
Yes, sir. All of them are related.
What
They are
kind of
brothers,
relation?
sisters.
What kind of relation?
Brothers, sisters, Your Lordship. The
Brothers.
respondents are brothers and sisters.
MS, your name?
M.
Address?
Tiwari. M. Tiwari.
M. Tiwari appears for the respondent number
1.
1. When was it served? Any idea? Date? Flag X part 2. The process server report indicates that the notice is served on 18/4/2023, but none has entered appearance for the other respondents. List after a month. And in the event none appears for the respondents 227, even after service of notice, the matter would proceed accordingly.
I will again apologize, Your Lordship. They are not brothers and sisters, Your Lordship. I mistake a different case.
And they were served otherwise.
Absolutely.
29. 1 month.
May it please your Lordship. Lordship, pursuant to order dated 5/8/2023, my lord, the learned CGC Council pays some time to obtain instruction.
Which order?
5/8/2023.
5/8. What instruction you want?
Your Lordship,
This
I
is
have-
an appeal.
Yes,
We'll
There
call
are-
for the records. We'll decide the appeal.
Yes, I have filed my affidavit, Your Lordship. I have annexed the written statement filed by the Western Railway.
No, that is not required.
required, but they have filed their affidavit in opposition.
No, in appeal, there is no scope of any affidavit.
Yes.
Has the records been called?
Yes, it is there, my lord.
Records received.
Yes, my lord, but my lord,
As per the order, in the order dated 5/8/20, it was reflected that MSK Fukan Learning CGC intends to obtain certain instruction. MSK Fukan informs the court that in the meantime, an affidavit has been filed.
Yes.
We have also noticed that the LCR of the order under appeal has been received. Matter be listed for its due consideration.
my lord, considering the urgency of the case, my lord, kindly a date may be fixed, because my lord, because of the railway fault, my lord, the consigner, the appellant has been penalized.
17/11/2023.
Deeply obliged. Obliged.
Sorry, my lord. 17 is
Today itself.
Start.
may I proceed, my lord?
Are you ready?
Some other day, Lordship.
MSM Sharma and Council appellant expresses certain urgency and ready to proceed ahead with the matter, but MS Kifukan prays for an adjournment to examine the matter. In view of the above, adjourned to be listed again on some date will be given.
Obliged.
Item 30.
May I please, your Lordship?
Yes, ma'am.
Lordship, restoration petition, Lordship. I have for restoration petition, Lordship.
Restoration. You are
Yes,
objecting?
Lordship.
We have an option. We need time to file an objection. my lord.
Inadvertently, Lordship, they missed the item, Lordship, while it was called on.
What kind of objection will you raise? That he deliberately did not appear and not missed it inadvertently.
They have given us a substitution petition. for the
Mr.
matter.
Counsel. The stand he is taking that inadvertently I missed out the matter. To object that, now you will have to establish that he did not inadvertently missed out, but he had deliberately not appeared. Do you have any material to prove that?
For that,
Then what kind of objection will you raise? Hmm? Let us restore it. Take a hearing on merit. Mr. S. Ali learned, has learned counsel also
A Sikdar.
G. A. Shikdar learned counsel for the opposite parties. This interlocutory application is for recalling the order dated 5/6/2023 in CRP IO 205/2022, by which the revision petition was dismissed for non-prosecution. Mr. S. Ali, learned counsel for the petitioner, raises a contention that on 5/6/2023, when the matter was listed before the court, the learned counsel inadvertently missed out the item and therefore could not remain present in the court. Mr. J. A. Sikdar. Mr. J. A. Sikdar, learned counsel, intends to file an objection. And upon such submission, a query is put as to what kind of objection would be raised. That is, whether the stand that the learned counsel had inadvertently missed out the item is an incorrect statement. No answer is forthcoming, nor it can be reasonably expected that an objection can be raised that Mr. S. Ali, learned counsel for the applicant, had made a false statement, and actually he had deliberately not appeared on in the matter on the same day. In view of the above, ordered recall, IOC restored to file to be listed for its consideration.
If
as
there
per
is an
the-
interim order, Lordship, that may be.
That will be in the CRP, not in the IA. You list the IA, we'll hear you on interim.
31.
May please, your Lordship. Lordship, it is statutory appeal, Lordship. Kindly appeal.
What is statutory appeal?
Lordship, appeal is filed by the by her father
No, what is meaning of statutory appeal
Lordship, under section 23, Reappearance Tribunal Act.
of the raid? Okay.
Yes.
What did we admit it?
Yes, Lordship.
Third, MSJ Kolita Land Conservancy admit returnable 6 weeks, steps on the respondent, registered post 3 days.
Lordship.
Call for the records of censure.
Public.
32.
32, yes. What do we hear?
I am appearing to respond number 1.
Others are served.
Others,
Mhm.
I have no knowledge about it.
1 and 2 you are appearing.
No, I am only 1.
1. The note of the process server as indicated in the office note dated 11/8/2023 is perused and is taken into consideration, from which it is reflected that the adult son of the respondent number 2 residing in the same address had accepted the notice. Notice on the respondent number 2 accordingly is accepted. List again to enable the respondent to enter appearance. They are related or different?
Different.
Not related. You know the number 2, don't know him.
I also filed a suit against him.
Okay.
34.
Yes, Mr. Kolita.
Lordship.
Delay.
Yeah, only delay.
How much? Objecting.
No.
He's a big-hearted man. Heard Mr. J. Kolita, Land Council applicant, also heard Mr. S. Bhattakur, Land Council for the respondent. This interlocutory application is instituted for condoning a delay of 36 days in filing the accompanying civil revision petition. Mr. S. Bhattakur in a manner to be appreciated, states that the respondent do not intend to object the condonation of the delay. Accordingly, delay of 36 days condoned. IA allowed the accompanying CRP to be registered and listed.
Copy of the petition to be served, madam.
85.
I'll serve.
You want a copy?
CPD petition, the main copy.
You want a copy?
He will provide, madam.
Why do you want a copy?
The main petition is CPD petition.
No, why do you want a copy?
It has gone to be numbered.
No, no. Why do you want a copy?
For argument, madam.
Why do you want to argue?
Sorry, madam.
Suppose I dismiss it in limine,
Yes.
then why do you unnecessarily enter the fray and create complication for yourself? Give him a copy if he wants, but otherwise, technically speaking, that may be dismissed in limine also, the end of the matter. But once you enter appearance, we are bound to hear you. And because of your submission, we may admit it, which otherwise we may not have admitted. Give me a copy if you want.
35.
Petition I have for condemnation of delay of 141 days.
You are A. Muhammad.
Yes.
Condoning delay of, has notice been served?
Yes, Lordship.
Are you sure? The office note of 14/11/2020 provides that neither ID card nor unserved notice of service upon the sole respondent had been received. Await service report.
36.
Hello.
Yes, Mr. Mullah.
Yeah.
IA for what?
This is an appeal against the order passed.
No,
by
IA
the-
for
the-
condoning 23 days.
Yes, my God, 43 days, delay is there.
Notice? Should we issue notice? Who is the respondent? Railway?
Railway.
Report goes. Get hold of one of the railway council. They are repeatedly appearing.
It was late.
Really advocate has been shown.
Huh?
Because really advocate has been shown.
I don't know. Get hold of one of the railway council. Number of them came some during the last 1 hour.
Yes.
Get hold of at least one of them. Mr. Molla must be thinking time to go home now. What kind of problem is this? Ask her to just follow on the railway council. Pisar mati dibo etu 2 দিন মান delay আছে.
37.
37, yes. What is this? For what purpose?
Please, the Lordship, the bill is time barred. We have filed a condemnation petition. The IA.
Delay of how many days? 189. Heard MS, your name?
P. Agarwal.
P. Agarwal and counsel for the applicant issue notice returnable 4 weeks. Steps on the respondents registered post 3 days.
39.
39, yes.
Is the Lordship.
For what purpose?
Lordship, this is a delay condemnation petition.
How many days?
216 days.
Objecting? No. Heard Mr. K.R. Borwal and counsel for the applicant, also heard your name?
Yes, Paul, your Lordship.
Yes, Paul and counsel for the respondents. This interlocutory application is instituted for condoning the delay of 216 days in filing the accompanying RSA. We peruse the grounds stated in the application for the delay. Particularly to the reason of frail health of the appellant. We have also heard the land counsel for respondents being satisfied with the ground taken, the delay of is condoned. Registry to register the accompanying RSA and list accordingly.
40.
Yes.
And
IA
75 days delay, my lord.
75. Has notice been served?
Yes.
Notice served? No, it's coming for the first time. How can notice be
First
served?
time, my lord, but my clerk has already informed me to meet the advocate of the other side. And inform me,
When you go back to your clerk, why you're coming to the court?
my lord. I am ready to.
Heard Mr. S.
MS Ali.
M. S. Ali, learned counsel for the MS petitioner. Notice returnable 4 weeks. Steps registered post 3 days.
41.
Mr. Mullah, you will not get your sleep this afternoon, but you'll get your order. Mr. Roy, you are for the railways. Is it delay of 23 days?
Lordship.
We want to record your presence and condone it using our discretion.
Lordship.
Extra copies may be given to the memo will be.
Why?
Delay condemnation.
Delay will already condone. But Mr. Mullah will have to wait. Yes, Mr. Sahu.
Your Lordship. Lordship, delay of 322 days.
Mr. Roy, will record your name. You did not remain present. We'll add you. Delay of
Delay of 322 days.
notice.
Heard
Miss S.
One more thing, this appeal has been filed by the third party.
You are a third party.
Yes. So.
You can file.
I filed an application for legal.
I think. No. First, I think we have to go for the delay.
Yes.
If delay is condoned, second stage will be whether leave to be granted or not.
Yes, Your Lordship.
In the meantime, file your leave application.
No, I have already filed. Your Lordship.
Already filed. We issue notice on both.
Both, Your Lordship.
দুইটাতে লিখি দিব হ্যাঁ IA 3328 and IA 3327
Yes.
As Sahu, notice 4 weeks, steps are raised for post release.
Item 42 for hearing.
My appeal, the second appeal, Lordship. Earlier, the matter has been heard by Justice Surana, my lord.
You want to go to that court?
No, my lord, I have just informed, my lord.
No, don't inform. If you want, you can go. We
No,
can
I
send
don't
you.
want, my lord, because
Then-
it was heard earlier, my lord.
No, that is not relevant for us.
So-
And if it is relevant, it has to go back to that court.
Yes.
Mhm.
Substantial question of law that was formulated by.
Mr. Dotto, ready?
I'm ready.
No, you are ready. Are you ready?
Maybe may not be taken up today, my lord.
Adjournment cost 10,000. Adjournment cost of 10,000. Will you pay it?
Yes.
You'll pay 10,000.
No, I am ready for argument.
2007 matter, almost 20-year-old now. Yes.
My lord, I am the defendant, my lord. It was filed for right title, interest and partition, my lord.
Uh, Where is the substantial question of law?
It was formulated on 23/11/2007. Section 90 of the Limitation Act, my lord, whether it is held in Exhibit C and D. 30 years old document, my lord. On that point, my lord, substantial question of law has been formulated.
What is the law of 30-year-old document?
This is section 90 of Evidence Act.
90.
Presumption regarding 30 years, genuineness.
So now what happened?
My lord,
It's a concurrent judgment or a
concurrent judgment.
concurrent judgment? So you are the plaintiff or defendant?
I'm the defendant, my lord.
Defendant.
I'm the defendant.
You rely on this 30-year-old document to prove your case. This was rejected.
That was rejected.
On what ground? Where is the rejection? Which paragraph?
Hello, may I draw your lordship attention to.
Mr. Shiladit, if you
Issue
come,
number 5 is the draft copy matter.
no, if you come straight away, it helps us.
Yes, that is. issue
Although I know you like to argue in a good elaborate manner, if you show us in which part of the judgment this 30-year-old document had been relied upon and why it was rejected.
Yes, my lord, on, I draw your lordship attention to page 23.
23.
Last part, from the very last line, my lord. So the plea taken by the defendant side that led Lakshmikanta,
Where you are reading, so.
last line, my lord.
So the plea taken by the defendant side that Lakshmikanta
Lakshmikanta Sharma during his lifetime sold away some of his land from his share for his treatment is not proved. The defendant side, though exhibited the sale deed number substantial, this is the exhibit, my lord, have been produced from proper custody. And state documents are more than 30 years old, but their value as evidence must be deposed.
Just a minute, huh? Yeah.
There are two parts in the section 90.
by which evidence you have proved that this is a document more than 30-year-old?
That is exhibit B, C, D, and F. That is in the file.
Sorry.
The original record. That is the time of the British era, my lord. Those are the documents.
British, French, we are not that interested. But at least it would be some. বড় এই এভিডেন্স একটা কোনখন লৈ আহকচোন ভিতৰত আছে ইয়াতে নাই ইয়াতে আছে নেকি এখন নহয় এখন চিপিছি এভিডেন্স মনিৰ নেকি এখন What does it mean? In this instance, the sale is exhibited by the presumption of its genuineness had been weakened by this circumstance. What circumstance?
That was not explained. That is the my case. Although court has first accepted that those are
Just a minute.
produced from the proper custody and the 30 years old document. But the second part, my lord, that was not explained by the trial court as well as the first appellate court.
Which part? Second part? What second part?
For taking presumption that are the genuine, my lord.
What kind of a sale deed? Is it registered?
Unregistered.
Huh?
Unregistered.
Unregistered, not registered.
Those are valuation below 100 rupees, my lord. It is not required mandatory.
That time it was not required. Witnesses were there, but very old document.
There was no witness, my lord. That's why we produced them and take the section 90 because this 30 years old document, neither the executor nor the witness were present, my lord. It was a 1930, 35, 1936 document, my lord. Although, my lord, both the court, my lord, held it from the proper custody, produced from the proper custody, and it is 30 years old. But regarding the genuineness, my lord, court did not explain anything, my lord, why it was rejected.
Who had passed this judgment? No, not this one. Even in England, where forgery and fraud are comparatively rare occurrence, the presumption mentioned in this section is applied with considerable care. Therefore, in this country, where forgery and fraud have been subject to frequent judicial comment, presumption must be applied with much more care and caution. Vaidya-Swami Iyer versus so-and-so, 69 IC, Indian cases, 1921. How can there be a judicial presumption that in India fraud is more and in England it is not there? Atrocious. And now it is the case they had stolen away more than $300 trillion of property of this country. And they are claiming that for them,
Forgery.
fraud and forgery is it's a rare occurrence. Yes. From whose custody you got these documents, the evidence? From whose custody these sale deeds were obtained?
It's independent.
It was in their own custody.
Yes, sir.
What kind of evidence you have rendered to prove that it is a 30-year-old document?
The document itself, my lord, because
Document itself is not sufficient. That's why I got the book to get it verified. I remember reading some time back that document itself is not sufficient because the section itself provides where any document purporting or proved to be. So the proof is required.
Yes.
So somebody has to render evidence. Suppose a old person in the house or somebody can say, yes, to my knowledge, this document was exhibited by my father. My father had told me about it earlier. That's a proving. Because the mere date in the document is insufficient. This is the law. You can go back and prove it. We'll allow you if you want.
no, my lord, here, my lord, it is said.
Understand? In order to draw the presumption in their favor, it must be proved that it's a 30-year-old document.
It was court has held, my lord. It was 30 years old document.
Where is it held?
It was, my lord. Kindly see, my lord, the fourth line, my lord. The defendant side bought exhibit substances and has been produced from proper custody. And the said document are more than 30 years old.
Based on what evidence?
Court has held, my lord. It was not challenged by them, my lord.
May not have a challenge, but on what evidence? Because it is you who is relying on it.
Evidence is the
Suppose the court would have held it on the basis of the evidence.
evidence is
Then
the
we accept it.
evidence
But
is-
any finding of a court divorce the evidence, it will not give you any right.
evidence itself, the document.
Mr.
itself, my lord.
Shilarita, you may go on arguing, we'll go on hearing, but it's going against you. We are asking you, do you want an opportunity to prove it? If you want, we'll send it back.
My respectful submission is that the document
Then we'll have to, we don't want to cause harm to your client. We'll have to dismiss your appeal.
was, my lord, document.
You can argue, we are only indicating. You can argue for days together, doesn't matter for us. But ultimately it will go against you. Please take note of that. If you want, you can prove it. Prove.
I will satisfy with lordship some other time, my lord, because at this point.
It has to be proved because there are many High Court decisions of that time of that. It must be proved that the document is 30-year old. You held that mere fact that the document is old enough is not enough.
My lord,
But section, it must be proved that the document is 30-year old. So one iota of an oral evidence is good enough.
it was, my lord, my evidence itself, my lord. DW4.
What did you say in your evidence?
It's a 30 years old document, my lord. It was executed in such and such year, my lord. It was
Exhibited where?
exhibit 4, evidence, my lord, DW4, my lord.
What did he say? What did DW3 say?
He said
That he knows about the execution of the document 30 years back.
he said these are the documents which was executed by the forefathers. It's a dispute between the families, my lord.
I know. He has to prove it that it is more than 30-year-old. And the law requires that mere date mentioned in the document is not enough. It must be one step beyond that. You prepare yourself. Come back. If you produce any judgments, we'll follow you. No difficulty. But it has to be.
Regarding that, my lord, I have to produce something.
Because 30-year-old is a very safe piece of evidence, but only thing, it begins with the word proved. Proved means not mere presentation. And you don't have to prove anything else. You have to prove that it is more than 30-year-old. That's all. 30-year-old as on the day the evidence is.
It was said, my lord, where any document purporting or proved to be 30 years old. Purporting or proved. It was not said.
Purporting also has to be established.
Purporting means I have said, my lord, it is 30 years. That has to be.
Mr. Shiladit, you are welcome to argue. Subject to the orders.
I will satisfy you another time.
To my understanding, that's been the law. Something has to be proved. Somebody from somewhere comes and make a statement. Your statement of disproving can also be hearsay also. Say you have an elder brother who is about 60-year-old. He can say that when I as a child, I heard my father saying that this was done. Good enough.
Same matters item 43.
What you are not required by section 90 is to bring back the executor of that document to the court and prove it.
Executor may not be possible to bring.
That is exempted. But not that mere just, this is the document, is 30-year-old. Or he can go by some other means also. He can.
Your lordship kindly look into this document, but it was there, my lord. Kindly look into this.
We are not looking. We are about to say that you could have sent it for a forensic verification also.
Forensic.
You could have, that would have been proving it.
Forensic regarding the genuineness.
Okay, let us take on. We are not interested in any debate with Mr. Shiladit. We have no business also. For the benefit of a client, we are indicating something. If we accept, we accept. Don't accept, don't accept. Up to you.
I know.
We are just indicating some of the means by which this aspect can be proved. If you don't like it, take it that we have not expressed it.
Sorry, man.
43. Yes, what is this? Transfer.
Transfer petition, lordship. I am for the husband and wife.
Who has appeared?
Lordship, that wife has filed the divorce proceeding in the bus.
No, you're for the husband.
I am
Has the wife appeared before the court?
Yes, lordship. The last occasion, counsel has appeared. And
None appears for the responded wife. List again.
45.
Yes, 45.
My lord, in this case, my lord,
injunction order was rejected by the municipal court, my lord, and the same is however allowed by the appellate court. That is challenged, my lord. The subject matter is a road, my lord. Both the parties are the successors of a common ancestor. And the property is my ancestral property. The path is also an ancestral path, my lord. During the respondent filed.
No, today what is to be done? Today, what do you expect us to do?
We are in the back end of the day. Any other convenient date is fixed for disposal.
No, today, for what purpose it
It
is?
is under stay order.
CIO of 2023 stated by Mr. Kadir
Yes.
that some medical inconvenience, interim order continue. This IO is against which order?
My lord, against the order.
Hmm.
Page number 52, man.
Sorry,
Page number 52.
52.
Yeah. That's from 54, my lord.
What is this misappeal? Is injunction matter?
Yes, in that.
The appeal sentence.
Subject matter is a my lord part, my lord. Both the party use the path, my lord. Their family were engaged in out there. And there was a my lord claim of the plaintiff itself. It is a 2 feet wide path, but the petitioner there in claim is a 9 feet wide path. And since there is a problem in summer season, my lord, for engagement out there, the petitioners there in try to develop the path, my lord, for the benefit of both parties. Both the parties use the path, the road.
Regarding what part?
Yes, my lord. Both parties use the path, my lord. To
You are the plaintiff,
I am the defendant.
defender. You are for the plaintiff.
Yes.
So they are using a path.
Yes, both parties.
So now what kind of injunction is given?
My lord, injunction given there, we should not develop the path. It is
Developments?
my lord.
Because the word develop,
Develop means, my lord, to
see,
art field, to art field.
the word develop
Yes.
is from putting one stone there up to constructing a innumerable number of floors of building also there. What do you mean by develop?
Well, art filling, only art filling, my lord.
You want to do art filling?
Yes.
Why are you objecting?
Because your
You also use the land, he will also use the land.
no, lordship is not the common path, but we have the alternate path also, but they are demanding about the 7.5 path. According to the law, according to the documents, only 2 paths is given to the pathway for walking.
Go a little slow. Speak a little slower so that we can. He is the defendant. You are the plaintiff.
Yes.
What is your claim in the plaint?
So basically, my claim is to, as the earlier this honorable court state, the injunction order given by the.
What is your claim in the plaint?
My claim is
Injunction will come only after filing a plaint.
to vacate the injunction order, to vacate the state order given by the honorable court.
We are not asking you a claim in this petition. In a plaint, originally title suit, what is your claim?
That the road given that they demanded the 9 feet ground for the path is illegal.
You are the plaintiff. Your claim doesn't depend on their demand. What is your claim?
That my property is sabotaged by them.
Oh, yes. Okay, adjourned on the prayer of parties. What else to do? Please come prepared. We wanted to decide it. But first, state us who is the person, what is your claim in your plaint. Then we'll understand what is his defense against your claim. Then we'll think of what kind of injunction to be there and what kind of injunction is not to be there. But you are starting always somewhere from the middle. So what is your prayer in the plaint? Read that at least. It's not there. Come prepared for these basic things. Once you come prepared, then we'll try to analyze what kind of right you are claiming, what kind of defense he is taking, who has a better prima facie right for that particular aspect, and we'll take a call on the injunction. If it is to be granted in your favor, we'll retain it. If it is not to be granted, we'll reject it. If it is something in between, we'll provide accordingly. But you have to, civil case, you have to go step by step. Hmm? Okay.
The interim may be continued.
Sorry.
The interim may be continued. Interim order is there.
Some interim is there.
Yes.
Okay, interim order till then.
Oblige.
What kind of interim order you have got?
The order of the appellate court is state.
What did the appellate court provide?
Appellate court, my lord, restricted us from the developing the road.
Developing.
Yes.
And what did the trial court provide?
Trial court did not rejected their injunction petition.
Trial court rejected injunction. What kind of injunction was sought for?
My lord, not to develop the path.
Not to
Develop the path.
whose land it is?
It is my lord, common ancestral road. We both parties are the successor of the common ancestral land.
Okay, it's a road going on.
Ancestral,
And what kind of development you want to do?
art filling, only art filling.
Why do you want to go for art filling?
My lord, my lord, photograph is given by the inspection report.
We don't not interested for the. Why do you want to do art filling?
My lord, both sides are get developed, my lord, with art filling, my lord, and it becomes like a drain, my lord. The path is.
Okay, the road in between is
Yes.
now
sides are-
low lying because both sides roads have been there.
Yes.
And what is their claim?
Their claim is that, my lord, that it is a 2 feet road. We should not expand it. But it is, my lord, inspection report came that it is a 9 feet, and our counter claim also that, my lord, it is a 9
No, out
feet.
of the 9 feet, they must be occupying some feet. Therefore, they don't want to.
Not
So some. And from where do you say it is a 9 feet road?
my lord, in the inspection report also it is reflected.
Whose inspection report?
The trial court, my lord, what are the Amin commission, my lord, they submitted a report, my lord.
Amin commissioner.
After spot
No,
check.
this 12 feet, 7 feet road is as per the map or as per the actual existence?
My lord, actual existence.
Your lordship, it is
You
there.
see,
My lord, roll-
Mr. Kadir,
Yes.
it is also a possibility that it is a 12 feet road,
Yes.
but your clients have encroached 10 feet from your side. Now the road is becoming 2 feet.
No, my lord, both
Just a
sides-
minute. Now the road has become 2 feet. And after becoming 2 feet, you want to, in the garb of developing, you will make it again 7 feet. So some of their land will be included. So definitely they may be aggrieved. So there must be some determination that 9 feet is as per the map or or as per actual existence.
Actual existence, man. It is reported by the commission. my lord.
No, but she says it is a 2 feet one.
But my lord, the report, my lord, is I have annexed the report, my lord. Report there.
So it is better you don't do any development work till it is decided, because what will happen is, moment we allow you to do some development work, suppose these boundary problems are very difficult and you don't know who is right, who is wrong. This is their land, this is your land, in between 7 feet. Suppose you shift a little this side, the road will become smaller. Of the common land, you may have gobbled up to 2-3 feet. And after gobbling up 2-3 feet, now if you take the stand, it's a 9 feet road. Few feet of their land will be now taken away by you in the guise of developing the road.
My lord,
Don't do anything.
my lord, both sides, their land is on both sides.
That is to be decided.
Both.
So don't develop anything.
My lord, that
So the trial court was right, appellate court.
the matter may come next week, any day, my lord, next time for final.
Otherwise, we send it back to the trial with a request for an expeditious hearing. Do it.
Yes. Yeah, my lord, any day.
Wait for a few more days. And if there is a drain, both of you purchase a boat to travel by that road. Yes.
My lord,
Mr. Kadir, if the road becomes a drain,
in the summer season.
summer season, both of you purchase one boat and travel that road by a boat.
But there is an alternate path.
But there is a possibility of you regularizing your. We don't know whether you are right or she is right.
My lord, report is there, madam. Inspection report is there.
Report says it is there is a requirement of existence of a 9 feet road as per the map.
Report says, my lord, that it is already 9 feet, my lord, road in existence. In existence, as on date.
बट सर कह रहे हैं कि आपने भी तो ले रखा होगा ना प्रॉपर्टी का कुछ हिस्सा, तभी तो रोड छोटी हो गई।
क्या हो गया मैडम?
नहीं सर, पॉइंट यही है कि ये जो बोल रहे हैं कि 9 फीट रोड है, 9 फीट रोड है, तो इन्होंने भी तो कंस्ट्रक्शन करके रोड छोटी कर दी ना। हमारे पास तो बची नहीं रोड। अभी हमारे जमीन से अगर हिस्सा आधा रोड का चला जाएगा
That is what we are trying to say, that there is a possibility of that.
My lord, next Thursday maybe, next Thursday.
29th. List on 29th for a hearing on this.
Till then,
Till
then, my lord, time.
Interim order to continue till 29.
Item 46 for admission.
With some little more information.
I have received the record and weightage for 15 years was not considered, madam.
It will did your record so when you take out. Today, I think we have. The civil matters take longer time, actually. Like writ petition, we can't go at that speed. No, a list on so it's stated by Mr. J.C. Gugoi that the records as required earlier is available.
21.
Heard Mr. J. Mullah, Learned Counsel for the applicant, as well as Mr. S.S. Roy, who upon the request of the court has entered appearance for the respondents in the Union of India in the Railways Department, in as much as Mr. Roy is as a CGC also appears for the department. This interlocutory application is instituted for condoning a delay of 23 days in filing the accompanying MFA against the order dated so-and-so of the Learned Railway Claims Tribunal in case number so-and-so particulars. On what ground? Why delay of 23 days?
My lord, the applicant is the father of the deceased, my lord.
Huh?
The applicant is the father of the deceased. And the applicant is aged about 70 years. And the tribunal, in its order, directed the registry to send a copy of the order to the applicant. But that was not sent. So
it was not sent.
That's not.
A ground is taken that the tribunal had required the order impugned to be sent to the applicant, but which was
not
received by the applicant. And it is because of this aspect that there is a delay of 23 days in filing the appeal. We are satisfied with the reasons for the delay being stated. Delay of 20 days filing the accompanying is condoned. I allow. Raised it to list the register and list the appeal. Sleep is gone. Afternoon sleep gone.